May I be also kind leave to mention one.
But extremely urgent matter. It is scheduled to be held on Sunday. My lord. Identical matter has been fixed by my lord at 12:30. My lord. My 254 my lord, identical matter.
No. Those who have mentioned I have listed.
তোমার তো গভর্নমেন্টের আমাকে তো পাঠিয়েছে, আমার গভর্নমেন্টই তো পাঠিয়েছে এই জিনিসটাই।
My lord, your lordship last occasion asked us to my lord screenshot or my lord the first page of the my lord Utshosri portal. My lord, I have taken my lord there are my lord 3 phase. My lord, I am just explaining, try to explain. My lord, what I understand, my lord, or understood, my lord, that the first my lord one teacher from anywhere, my lord, one just suppose my lord, I'm just giving an example of a teacher of Howrah. My lord logging in the Utshosri portal and my lord give his or her details, the school, and my lord he want to take transfer in the suppose my lord in the district of Howrah. So my lord the other part will my lord see whether if it is matches with his or her, my lord he will accept, and my lord give his my lord all my lord the documents. My lord documents means my lord the completion 2 years completion. Thereafter my lord it will go to the my lord the SI, the end of the SI. My lord SI will see my lord whether he was transferred within 5 years or not, and thereafter the SI will send it to the DPSC, District Primary School Council, and my lord District Primary School Council will give. My lord, if it is a my lord transfer in respect of the my lord inter-district, then my lord it will be sent to the board. My lord, the secretary of the board, my lord, secretary of the board will my lord, after getting all these things, my lord, it will give. My lord, just my lord, I am handing over your lordship the first page. My lord, second and third also, my lord, I am giving, but my lord, the not legible, my lord, the other two, because my lord, I'm not getting it, my lord, from the screenshot. If your lordship asks me, my lord, I can give your lordship the demonstrate the live, my lord, from the laptop.
Go back to the authority and file an application through Utshosri. What is the difficulty? But how do you tag the person with whom I will be asking for mutual transfer?
Suppose, my lord.
Suppose A files an application for mutual transfer.
Mutual transfer.
With B.
No. Now, I'm trying to clear myself. But I am a teacher. But I seek the transfer, mutual transfer. Malad, put in the Malad the website my details. Okay. Saying Malad that I want to transfer such and such district or such and such circle or such and such school. Malad, if someone, Malad, the interested person can also Malad logging into the portal and Malad can see is there any similar person asking transfer the particular post. If he finds Malad or she finds Malad that it is matching with my requirement, then I will accept it. Your lordship will find request accepted by the teacher, Malad, right hand column. The first page right hand column, Malad, this one, your lordship, the first one is Malad logging by the teacher one, and then Malad the right hand column, the accepted request accepted by the teacher, code, teacher designation, transfer proposal, ID, teacher gender, then Malad teacher mobile number, school name. Malad, by these details, Malad SI or Malad DPSC will find everything of the teacher, whether he was transferred within in the meantime or not, everything, except my lord teacher relation. This is the my lord the
Okay. Ashok.
My lord, kindly hear me for a moment. My lord, this petition is a prayer for mutual transfer. My lord, the word mutual itself is
No, we are not into that.
My lord,
If there is a process which is in line and existence, one has to adhere to that
I'm coming.
process. File an application. I grant you liberty. File an application through Utsutri. If there is a available person, that will be done.
I'm coming on that aspect. Now, kindly allow me only 2 minutes, my lord. Kindly allow me only 2 minutes.
Extensively, I have heard you. I have just wanted to know what is the process.
My lord, kindly, my lord,
Ashok.
when the
No,
application,
Mr.
my lord, kindly hear me. My lord, when the application was made, then at that point of time,
That point of time, even if it is not there, I grant you liberty to file an application, right?
Kindly hear me for a
Tomorrow,
moment. My lord.
no.
Kindly hear me only 1 minute, my lord. Kindly hear me only 1 minute, my lord.
Ashok. This matter is appearing under the heading for orders. একই order হবে 1 2 এই আরো তিনটে দিন তো
Follow.
Regarding
The-
item number 3 and 4, may appearing for the same.
no Mr. Bari,
My lord.
can a single order be covered with all the cause of actions are different?
No, my lord, cause of action was same, but in case of second petition, my lord, there is some subsequent facts, my lord, I want to address you before your lordship. My lord, in the second matter, what happened?
Second matter, my lord, I am appealing for the state responding.
The second matter, my lord, kindly first, third, and fourth, maybe similar order may be passed. But in case of the second matter, my lord, kindly allow me to say only one thing, my lord.
First,
Second.
third, and fourth. First, third, and fourth, they have come mutually. Okay. Yes. Second matter.
Second matter, my lord, though the three petitioners, my lord, applied for mutual transfer, subsequently what happened, my lord, suppressing me as well as suppressing the board. The petitioner number 1, Abhishek Chatterjee, he applied mutual transfer to with another person. And perhaps board was not aware, and the board allowed such transfer, and they have already joined in their new post. This is the fact. I am leaving your lordship, but what if your lordship pass necessary order?
Then you are left with 2 persons. Let them apply before the.
Yes, my lord, that liberty not. I am not
Three,
trying.
they have opposition to 3. If 2 is left, Abhishek goes. Then rest of the petitioners are granted liberty. You file an application.
Yes, they will grant. I am praying for liberty to file afresh.
In all
for
the
their
applications, I
transfer.
grant you liberty. Take online application, make online application, let them consider.
Not for
this is the predicament in the offline transfer. My lord, if it is on portal, my lord,
The
if it is
board
on
would have-
portal, everything, my lord, one cannot, my lord, suppress anything.
Yes. Sure.
my lord, petition number 2.
One-
Kindly, I am praying for
1,
only
1, 3, and 4.
1, 3, and 4.
3 and 4, am appearing for the same.
Petitioner देखिए the petitioners in all the writ petitions are assistant teachers under different district primary school council. The petitioners in WPA 4175 of 2025 এটা এরকম ভাবে করুন petitioners in WPA 4175 of 2025 applied for mutual transfer. All the petitions বলেছিলাম না?
দুই আলাদা হবে।
All the petitions বলেছিলাম। ঠিক আছে, ঠিক আছে। The prayer of the petitioner, where is the impugned order? The prayer of the petitioners was turned down
Page 38, madam.
by the West Bengal Board of Primary Education, applying the rules, particularly Rule 3(1) of West Bengal School Service Commission within bracket Mutual Transfer Rules 2012. Since the rules pertaining to transfer under West Bengal primary education, there is no existence. Since there is no existence of relevant rules for transfer of 3 teachers, effective mutual transfer. Being agreed by such order, orders karo. Orders are passed on the same date.
Same day.
Agreed by such orders passed by the Secretary, West Bengal Board of Primary Education on 17th January 2025. The petitioners have preferred the respective writ petitions. Mr. Samimul Bari, learned advocate for the petitioner, submits that this matter is appearing under the heading for orders. Submits that there is no such provisions in the West Bengal primary education transfer of teachers, including head teachers bracket close rules 2002, hereinafter referred to as rules of 2002, debarring 3 persons from seeking mutual transfer. The impugned order under challenge has been passed by the Secretary of the West Bengal Board of Primary Education, basing on the rules applicable to secondary education. In the, they have filed report or affidavit in opposition? Report.
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 In its report, the board has admitted the fact that there is no existence of such rules.
No, board has not, but state has.
State has filed a report.
Oh, state.
Yes.
Pursuant to the order of this honorable court.
Deputy Director State has accepted the fact that there is no existence of rules for transfer of 3 teachers for mutual transfer.
Reciprocal plus. Reciprocal transfer.
Referring to the supplementary affidavit, he indicates that the chairman of different councils,
And I have also annexed the writ petition also.
different councils have passed orders for mutual transfer of 3 persons. Thus, there is no bar as such to accede to the prayer of the petitioners seeking for their mutual transfers. Stop. He seeks for setting aside of the impugned order. Mr. Subir Sanna, learned senior advocate, along with Mr. Ratul Biswas, learned advocate for the West Bengal Board of Primary Education, referring to Rule 4B of the Rules of 2002, submits that the language of these aforesaid provisions starts with the sentence that a single application is to be filed by the teacher seeking for such mutual transfer. Further, for the administrative convenience, the mutual transfer of 3%, mutual transfer of more than 2% is uncalled for. The orders passed by the different councils as relied upon by the petitioner is dehors existing rules. He also indicates that for mutual transfer, the concerned teacher has to apply online through Utsosri portal, which is effective since the year 2024. He seeks for, in light of the aforesaid submission, seeks for dismissal of the writ petition. Stop. However, he informs the court that if the petitioners file application for mutual transfer through the Utsosri portal, the board will consider the same in accordance with law. In reply, Mr. Bari, learned advocate appearing for the petitioners, submits that the technicalities cannot be a bar for a person from getting the benefits under law. He also indicates that the application, as when filed previously, he also indicates that at the time when the applications of the petitioners were filed, the online portal was not effective. Admittedly, pursuant to order of this court, the board has produced this has been downloaded from the website.
Website.
Portal.
Produces the mutual transfer application details downloaded from the portal. The said page records the column request initiated by and request accepted by. Learned advocate for the board informs the court that the process is that whenever an application is filed by a teacher seeking for transfer, the details are uploaded, and if any teacher is available for mutual transfer, the request is accepted accordingly. Upon hearing the learned advocates for respective parties, it is a fact that
Just now, I'm given, if your lordship, the entire thing lordship will find, the color, then your lordship.
Devnath Babu,
Kindly excuse me, just now, actually it is very difficult to take print out, entire thing.
আপনারটা ওটা কেটে দিন।
হাওয়াটা কম করে না।
কেটে দিন। Rule 4B clearly envisages that an application is to be made by a teacher seeking for mutual transfer or single transfer. The portal of the board, namely Utsosri, has been designed for processing the transfers, particularly single or mutual. Therefore, it is found that the petitioners have not applied through the Utsosri portal. Since such portal is in existence for effecting such transfers, it will be appropriate for the petitioners to avail such online portal seeking transfer. In light of the aforesaid discussion, liberty is granted to the petitioners to apply online through Utsosri portal within a period of 4 weeks from date. Upon such application being made, the board shall consider the same in accordance with law. With the aforesaid observation, the writ petition stands disposed of. 4 weeks time has been given. If they file, you will consider that. Where is the second one?
3 persons cannot apply. 3 persons cannot apply.
So they'll apply separately. Okay, separately that liberty is granted to apply separately.
Yes,
So which of the person has already applied and got the mutual transfer?
second madam, petition number.
ওটা সেম থাকবে petitioner seeking mutual transfer. Mr. Samimul Bari পুরো সাবমিশনটা থাকবে, শেষে বলবেন he informs the court that one of the petitioners,
Petition number 2.
Abhishek Chatterjee, without informing the other petitioners, have already applied for mutual transfers through the online portal. বাকিটুকু
Not online portal. He also applied offline.
offline, has already applied for mutual transfer through offline.
Which was considered
such-
and effective.
Which was considered and allowed.
Yes.
Acha. So, in such event, he presses the writ petition, prayer of the writ petitioner, number 2 and 3.
1 and 3.
1 and 3. এখানে শুধু ওপরে বলে দেবেন ওই চেঞ্জটা হবে যে 1 and 3 are granted liberty to file separate applications. Disposed of.
1, 2, 3, 4.
Since we have not used any affidavit, all the allegation is denied. That may be noted.
No. ওর প্রেয়ারটা প্রেস করছে। নাম তো এক্সপেন্স করবে না।
But since we have not used any affidavit, all the allegation is denied.
Where Baba stated against the grievance.
Grateful.
Yes, thank you.
May I file my opposition?
On the last occasion, your lordship had directed.
না এগুলো থাকবে। এই কালকে যেটা চেয়েছিলাম সেটা আছে তো আপনার কাছে? চাইলে আমাকে পাঠিয়ে দাও, কারেকশনের সময় বলে দেবো কোনটাই দিতে হবে।
May I
Your
file my
lordship,
opposition?
On the last occasion, your lordship had directed filing of the affidavits, but since it has been affirmed today, my reply, here and now I am serving a copy. I have also served this.
Affidavit in opposition, filed, fix another date.
No, it can be heard today, my sir.
চল ঠিক আছে, বলুন এটা দেন। Where is the reply? Can affidavit in reply. Okay. Yes.
The lordship is hearing, the recalling application. This recalling application was filed in respect of an order passed by your lordship on 27th of October. In this matter, it is alleged that the applicants have constructed illegally and unauthorizedly constructed certain portions of the building which is encroaching the public pathway. This is the allegation against me. Now, my lord, the Honorable High Court had passed an order directing that the Panchayat Pradhan to hear out the issue in presence of all the parties. My lord, in that hearing which took place, no notice was admittedly served upon me. But this order, which was passed on April, as I did not receive any notice of hearing, but on July, I made a written reply to the Panchayat Pradhan stating that though the Honorable High Court had directed, may I place the order of the High Court for once? My lord, kindly comes to page 37, it starts, the order of the Honorable High Court. Page 37 of my recalling application. Yes. Kindly takes page 38 for once. Page 38, I am placing the second paragraph. The writ petition is accordingly disposed of by directing the respondent number so and so to consider and dispose of the representation made by the petitioner strictly in accordance with law after giving an opportunity of hearing to all the necessary parties, including the petitioner at the earliest, but positively within a period of 3 months from the date of communication of a copy of this order. My lord, your lordship will kindly thereafter take the P6, which is at page 40. Yes. My lord, I write a letter stating that by an order this, the Honorable Court has directed this. Now, we are waiting, however, till if your lordship kindly comes to the last paragraph. However, till to date, even though the period specified by the Honorable High Court has expired, no notice of hearing to be conducted by you has been received by either of us, and hence we have thought fit to bring the said issue to your notice. Well, interestingly, this time, for the first time, when this matter is being now heard by this Honorable Court, by a letter which is annexed to the opposition, if your honor kindly takes up, on 7th of February, a letter of 7th of February is now used. Yes. This is a communication of 7th February, which states that on 4th of June 2024, we had been served a notice and we chose to refuse to accept the said notice. This is now being given at this stage after maintaining a stoic silence for over 1.5 years. Now, my lord, after I do that, I visit the Panchayat office and with much difficulty I find out that a letter, I don't get any copy of any order. If your lordship kindly takes up page 41, this is, I find with much difficulty that a letter had been issued by the Panchayat Pradhan to the learned advocate appearing on behalf of the writ petitioner that this is an illegal construction, this and that. Thereafter, this writ petition had been filed. This writ petition 17839 of 2024 had been filed by the petitioner seeking a direction from this Honorable Court that since the Panchayat has held the structure to be an unauthorized and illegal one, so demolition process may be carried out by the SDO, and a direction for referring this matter to the SDO under section 23(5) of the Panchayat Act was filed. Well, this matter which was filed was supposed to appear in July 2024. The Lordship kindly takes up page 43 for once of my recalling application.
Yes. 43.
Yes, Your Lordship. My lord, the matter was due to appear in the list on July 18, 2024. My lord, on that day, the matter did not appear. My lord, the learned advocate of the respondents therein, she wrote a letter to the learned advocate on record of the petitioner stating that I have been instructed to appear on behalf of this respondents. So as the matter is not appearing today, in the event it appears sometimes later, kindly inform me. This is that letter. Well, therefore, thereafter the matter does not appear, and so it again appears in the monthly list of February 2025. The matter was delisted. Subsequently, though it is a fact that the matter was being looked into in the September combined list, the matter was not there. On October 24th, the matter was not there. On 27th October, the matter appeared before Your Lordship without serving any notice upon the learned advocate on record that the matter is being mentioned for being taken out of turn and the matter will be heard out. Even after the matter was mentioned and the matter was due to appear on 27th, no such notice has been given. But in the affidavit in opposition, there is no denial to this fact that no notice has been served upon the learned advocate of the petitioner, of the respondents. It has merely been stated that listing and delisting of matters, these are the administrative domain of the Honorable Court, and therefore nothing as though Your Lordship knows that it is the usual practice that as a notice is served. Well, due to that, the learned advocate on record failed to notice that the matter was appearing on that day, 27th of October, and the matter was heard out, and as a result of that, the facts of the case, the merits of the matter could not be placed before the Honorable Court. And the Honorable Court has passed an order, which Your Lordship will find at page 44 of the recalling application. Now, so far as the merits of the matter are concerned, may I place the merits, or Your Lordship will first hear out?
First or second, on the first instance, I told you that I will decide on the recalling itself. The merit that will go to the court having determination.
Great. That order is at page 44, which Your Lordship has passed.
Yes.
My lord, may I just say this? My lord, my learned senior friend has strenuously argued that when it comes to the hearing, which was supposedly given by the respective authorities, he did not have notice of the same. He did not participate, for which the impugned order was passed. May I ask this question to myself? Thereafter, was the impugned order challenged? The answer is a categorical no. My lord, the impugned order is at page 42 of their recalling application. This is the impugned order passed by the Pradhan of Aranghata Gram Panchayat.
Yes.
This has remained unchallenged till date, to the best of my knowledge, subject to correction by my learned friend. I don't think there is any writ petition which challenges this order. If this order is not challenged, then the facts in this order remain sacrosanct. What does that order say? However, the illegal act on the part of the aforementioned persons, normally Amalendu Dubey, Indrajit Dubey, Shujit Dubey, ensuring that no ambulance can reach his premises at all. In this situation, specifically, I'll read from the very top. I say that Amalendu Dubey, Indrajit Dubey, Shujit Dubey, resident of Aranghata Gram Panchayat, they constructed a building on a land measuring about 17 decimal under police station Dhantola, district Nodia, JL number 49, Mouja Aranghata, Narayanpur, Ranaghat, without any sanction plan from the Pradhan. There is no building approval plan from the Pradhan of Aranghata Gram Panchayat in this circumstance. Panchayat road has become so narrow that the car ambulance cannot pass through the road at all. People at the locality are facing huge problem. This is the issue. Today, construction has been made by encroaching a public road, and ambulance cannot go in, a fire engine cannot go in. Thereafter, my lord, however, the illegal act on the part of the aforementioned persons, normally Amolendu Dubey, Indrajit Dubey, Shujit Dubey, ensuring that no ambulance can reach his premises at all. That is my premises. In this situation, the Gram Panchayat authority unable to demolish the construction Panchayat authority wants higher authority take over the matter and peacefully resolve the above problems. So ambulance will not be able to go, a fire engine will not be able to go, nothing can go. But Panchayat thinks that higher authority should resolve the matter. And this was, according to me, notice was given to them. And even if, is assuming but not admitting, today I have annexed in my opposition two notices which was relied upon by my learned senior friend, that notices were given. Of course, it is for the Panchayat to specifically give the track report or give specific documentary evidence that the notice actually was given. But if this order, in fact, an affidavit has been affirmed by the Pradhan of the Gram Panchayat saying that hand service has been refused by them. That is at page 12. Page 11, my lord. This is an affidavit by the Pradhan of Aranghata Gram Panchayat stating that it is intimated that due notice has been served to all affected parties by the local Gram Panchayat by hand service. Out of them, Krishna Bhaumik has received the notice, that is my client, for attending the hearing, but Amolendu Dubey, Indrajit Dubey, Shujit Dubey has refused to receive the notice. A copy of such is for your kind reference. So it is only my client who has received the notice. Others have refused to receive the notice, for which this notice hearing was made ex parte. Today the hearing order has not been challenged. So today when I seek implementation of this order to my lord, quite naturally stated that I did not properly seek implementation. I also challenged that order on the ground that Panchayat cannot say that there is encroachment, ambulances cannot go through, fire engines cannot go through, but I am helpless. That cannot be the stand of the Panchayat, and that is why my lord had passed appropriate orders for taking appropriate steps for demolition, not for demolition. My learned senior friends, clients has ample opportunity before the appropriate authority, even thereafter. Today, after this, what remains, my lord? The only thing what my learned senior friend says that yes, my learned senior friend said that if the determination changes, we should intimate them. That is a letter which we have received. Determination determination we did not intimate, but it is not that the matter was taken out of turn and we did not intimate it. It came into the list by normally. And we also came to know of the matter from the list. We appeared, and affidavit of service was taken on record. The order at least records that. That is what the order records.
This was not out of mentioning.
Yes. It neither appeared in the September list, not on October 24 also.
There is a responsibility to the learned advocate who is following the list or who is appearing for the respondents.
I bow down.
The list
I
which
bow
comes up is a notice to the learned advocate.
bow
all the
down-
learned
I
advocates.
bow
It
down
is
to
for
your
you
lordship.
to follow the list. Now the thing is, did you mention the matter or it came up normally? If it is mentioned, show me the letter that he says that mentioning letter was not served to him. For
At
which
least
reason
my
he didn't
advocate
have the notice that the matter will be listed or will
I
be
did
taken
not
up by the
personally mention my advocate on record. Please. I did not personally mention my lord. That much I can assure my lord. I did not personally mention this matter.
But this is a fact that he says that is being mentioned and that.
I do not
Others
know
cited-
if
This
my
was the
my
27th
lord's
October.
my lord's
My lord.
my lord's
Takes us
record
27th
if there was a mentioning at least a mentioning slip will be there in the records. If
It
there's
is not
it is
there.
not it's not there, then could not have been mentioned. If it's not there, it could not have been mentioned, because I can vouch for that I have personally not mentioned this matter.
মেনশনিং স্লিপটা কোথায় থাকবে? না ওটা কি বার করে দেওয়া হয়? ও তাহলে কি করে বুঝবে এটা? আচ্ছা। So, sir, how did you say that it was mentioned and then listed?
My lord, kindly see 27th October.
This does not say that it was mentioned.
It
It is
appears that at the top, item 26, your lordship.
that the word, only the word top is there, nothing else.
Top, as your lordship found it, item 26.
That is
Lordship,
there, but I do
in
not.
the September's combined monthly list which came out,
Hmm.
in the September and in the October, no combined list was published. So this was the monthly combined list which was taken up for hearing. Well, your lordship kindly sees that in the list of the combined monthly list of cases, this matter does not appear even. This is your lordship. This is the combined list. This matter does not appear in the combined list of cases. Nowhere it is there. And this is the list of 24th October, the date when the courts reopened after the Puja vacation. It was also not in the list. If it could have been in the combined monthly list, then also I could have understood.
The only thing, my lord,
Nowhere it is there.
my lord, if the records do not
And
show
one,
that there has been mentioning, I have my advocate on record has no obligation, unless it was mentioned, it has no obligation to inform my learned friends of the matter. And if that is the case, the list was published. That is an admitted fact that the list was published. It was the matter was appearing in the list. And today, what will the recalling serve today? Today, admittedly, an order has been passed. The order which has been set aside.
Oh, that is correct.
What
Now, they will
purpose?
get the opportunity before the SDO.
They will get their opportunity before the SDO. What?
and your lordship, it has been submitted that the order which was passed by the Panchayat Pradhan, no, I have not challenged that order. Well, I have specifically challenged that order by filing a writ petition which has been served upon my learned friends, WPA 20434 of 2024, which is still pending for adjudication. It has been served.
কি বলছে?
What my learned friend is stating that I have not challenged that order.
বলছো না কেন আমাকে?
Mr. Ghosh, please, this is a recalling application.
Right.
If it is required to be heard on merits, if there is a pendency of the writ petition, you say that I do not have the knowledge. If you don't have the knowledge, take the proper instruction and come before the court. Now he is claiming that there is a writ petition which is filed in the year 2024 challenging the order of the Pradhan, and that is pending before this court.
Pending before this.
Even if in my humble submission I have
No,
said,
at the first instance, why do you submit that there is no writ petition? It was never challenged.
I was under wrong impression. I bow down to your lordship. But in any ways, in that writ petition, my learned friend will know better. I'm not briefed in that matter, but my learned friend will know better. Has a stay order or any interim order has been passed in the matter?
No, it has not
a
yet been
separate-
taken up.
Then nothing remains.
Who is your advocate on record?
My lord.
Did you file any application mentioning,
I cannot recall it right now, madam.
you don't
There's
recall
so many matters I am mentioning, so cannot recall it right now.
If you cannot recollect the aspect, then how the court has given a bracketed that with top, written top? Without mentioning, can the court so to make a matter
That my
top
my
of the
lord, I
list?
leave it to my lords. I cannot comment on it. If my lord deems fit that it was mentioned, then it is the fault of my advocate on record. I cannot
I am
run away from it.
clarifying myself
Mm.
that there are 100 matters, but some of the matters are designated or indicated as top. Without mentioning by the learned advocates, can the matter be indicated as top?
But I
Follow
leave it
the
to your
list which
lordship
he has
because
given.
I don't have.
In motion 21 to, on that day, 21 to 30 was top, indicated top, but 31 is not indicated as top, which presupposes that there has to be a mentioning by the learned advocate for taking the matter expeditiously. That is what I understand.
If
You can deny-
I cannot because I do not have knowledge of this, for which whatever falls for my lord, I cannot
Ashwin, you have annexed the order passed by the appellate court.
Yes, your lordship. That is at page
50.
Your lordship 50, page 50.
Can 1 of 2026. This is an application for a recall of order dated 27th October 2024, passed by this court in WPA number 17839 of 2024. In an earlier round of litigation, being WPA 22055 of 2023, a coordinate bench of this court. This was filed by whom? Krishna Bhomik is it?
Krishna Bhomik is my client.
Ajab. Filed by one Miss Krishna Bhomik. The coordinate bench of this court passed the following direction. Pursuant thereto, orders were passed by the Pradhan on 26 June 2024. Without there being specific order for demolition of construction. Para. Subsequent thereto, the petitioner, Miss Krishna Bhomik, filed another writ petition being WPA number 17839 of 2024. Which was disposed of on 27th October 2024, 25, with the following direction. Para 13. Para 13. We order para 13. The aforesaid order was challenged before the Honorable Division Bench in appeal being met 2000 of 2025. In which paragraph this liberty was granted?
Lordship. Your Lordship kindly comes to the next page, that is page 51. From para 5, if your Lordship can.
And liberty was granted to the appellant to file application before the learned single judge with sufficient grounds to demonstrate that matter was proceeded ex parte without due notice to him. Para. Accordingly, the applicant has filed the present application for recalling the order dated 27th October 2025 passed in WPA 17389 of 2024. Mr. Krishnendu Sarkar, learned advocate for the applicants, class respond number 6, 7 and 8, submits that neither the Pradhan of the concerned Gram Panchayat has proceeded with the hearing without service of any notice upon the applicants. The writ petition was listed lastly on which date? This writ petition?
17839. That was on 27th October.
No, prior to that, after filing, it never came
After
up.
filing it in February
Oh.
2025, it appeared in the
Submits that.
combined list.
Listed initially in February 2025 and thereafter it never appeared till it was listed on 27th of October 2025 upon mentioning by the learned advocate on record for the petitioner. No notice of mentioning was served upon the learned advocate for the applicants. Therefore, the applicants did not have any knowledge regarding the matter being taken up by this court. He seeks for recalling of the said order dated 27th October 2025. Mr. Sonak Ghosh, learned advocate, appearing for the opposite party, numbers 6. Opposite parties are for the petitioner in the writ petition submits that the matter has come up on 27th October 2025 normally. Upon inquiry by this court, he submits that he cannot recollect whether any mentioning was at all made before this court or not for expeditious hearing of the matter. para. Upon going through the daily list of 27th October 2025, it appears that the matter has been listed under item number 26 with the indication within bracket, inverted comma, top, which in all probability has come up with such indication upon being mentioned. In mention. Nothing has been placed on record that such mentioning was notified to the learned advocate on record for the applicants. In view of the above, the order dated 27th October 2025 is hereby recalled. The application being Can 1 of 2026 is disposed of. Now it goes to the court having determination.
Yes.
On the only thing, Mad, since my learned senior friend's submission is that the impugned order by the Pradhan has been passed without giving any notice. If it is my submission is recorded that is being disputed by me. That is the only.
Mr. Sono goes, his submission disputes the fact that the notice was not served upon the applicants by the Pradhan prior to taking up the hearing pursuant to order passed by this court. The order passed in the appeal indicates a single bench. It does not specify that the order which has been passed by this court. So it goes to the court having determination?
It goes to the court having determination.
Okay. Disposed of. Acha, operator niya affidavit in opposition, affidavit in reply. Let the matter be listed before the court having determination.
Grateful, my lord.
Just give a copy of this list. Give a photocopy of that.
Of this list, yes. In the course of the day, I'll submit.
Oh.
Grateful.
তো ওদের কাছে থাকবে? ঠিক আছে, তাহলে না বলে দিন। চলো। Then appears on behalf of the petitioner. Not in the affidavit of service is fine. For ends of justice, the matter is adjourned. List this matter after 2 weeks under the same heading.
I'm for the petitioner, Lordship.
My lord, they have cited, my lord, one judgment.
আরে এটা প্যারাগ্রাফ 5 না 7 কোনটা দেখেছি?
এটা জাজমেন্টে পড়েছে
প্যারাগ্রাফ অতটা তো পড়ে লাভ নেই। রেশিও কোনটা বল?
স্যার এই জাজমেন্টটা হ্যাঁ
কোনটা রেশিও? 53
কোটলাল তো
হ্যাঁ, রামনারায়ণ সিং। এই
প্যারাগ্রাফ 1953 তো
প্যারাগ্রাফ 5
পোপটলাল শাহ ভার্সেস স্টেট অফ মাদ্রাস ইউনিয়ন এন্ড আদার্স
কি
পোপটলাল শাহ ভার্সেস স্টেট অফ মাদ্রাস
পেজ মিন
AIR 1953 AIR 274
সুপ্রিম কোর্ট হ্যাঁ 274 পোপটলাল শাহ হ্যাঁ এর প্যারাগ্রাফ কত দেখিয়েছিলি?
ওটা তাহলে জাজমেন্টস গুলো আছে
এখানটা পড়েছিলাম এটা
প্যারাগ্রাফ কত?
প্যারা 5 দেখি এটা তো কোনো প্যারা দেয়া নেই দাদা আমি তো
হয়নি
আমি তো মানে আমি অ্যাকচুয়ালি এ থেকে তুলেছিলাম তো এই যে এইভাবে পড়েছিলাম আমি জজকে এইভাবে এইটাই দিয়েছি
আচ্ছা, কোথা থেকে
তুমি
বলছো?
দেখো এইটা
আচ্ছা পেয়েছি প্যারা 5 নয়। প্যারাগ্রাফটা কি দেখি তোর আর একবার দেখি।
is a settled construction of law
এই প্যারাগ্রাফটাই এইখানে দেখিয়েছিস গোটাটা দেখি
গোটাটাই করেছে এই প্যারাগ্রাফটা গোটাটাই করেছে
Yes.
My learned friend has cited two judgments to controvert my submissions, but my humble submissions, both the judgments are in my favor. Because I tell you, losses why. But admittedly, the rule points out that it is applicable to inter-school. Inter-school, na inter-school, inter-school. Same rules, even by initially there was rule 8 which applied to intra-school. Even that was amended widely and again, my lord, inter-school applicable in the same rule. So, my lord, when the subsequent provisions clarifies that this will be applicable to inter-school school, title cannot dominate the entire rule. The entire rule has to be read as a whole. And one more thing, your lordships, state is not incompetent. Board has given power to inter council transfer by section 19, if I'm not wrong.
19K.
19K. Similarly, my lord, the council has the power under section 60K. So, kindly, your lordships, rules. Act.
It's there in the spiral binding.
No. Act, my lord.
your lordship kindly take the education manual one
Volume 1.
and my lord yes volume 1 so lordship kindly come to on that page
Plus section 9, 19K, 1K.
তুমি 91 কে দেখাচ্ছ না 62 কে
দুটোই দেখাচ্ছি আমার উদ্দেশ্য যে
Secondary cohort.
your lordship kindly come to page 20 of that book that is 91
same edition.
oh একই
Yes.
91 কে
19
19.
19
Yes.
subsection 1. I placed it before last.
Yes.
Subject to any general or special orders of the state government. The provisions of this act and rules made thereunder, the board shall have generally power to guide, supervise, control primary education, including primary teachers training, and in particular the power, kindly read your losses K, to transfer.
Teacher not in the form of primary school within the jurisdiction of one primary school. Two primary school.
But even as a student of law, if I go through simply, our teaching is that don't go to the judgment first. Read the law first.
Yes.
So if I go by your lordships, state retained its power. Even legislature gave them the power to, but state retained its power to control it. To what extent? Subject to any general or special orders. Subject to any general order, special order means my lord rules. Then again, your lordships kindly consider section 60K. Duties of the primary school council, 60. My lord, it shall be the duty of every primary school council. My lord, again, the sub rule K.
When teachers and other
subject to the prescribed conditions. Prescribed means prescribed by rules. Power, my lord, this is intra-school, within the council jurisdiction. So both the authorities has the power, but how to be regulated, my lord? Unless the rules are framed to carry out the purpose of the act. Kindly, your lordships, see section 105, if I'm not wrong. Correctly remember, your lordships. 105. Rule making power of the state. 106, my lord. Kindly see subsection 1. The state government may, after previous publication, make rules for carrying out the purpose of this act. One of the powers, your lordships, to transfer the teacher, purpose of the act. How to be regulated? By the rules. Now, kindly, your lordships, if your lordships proceed with this, your lordships will not find anywhere mentions section 90 or even section 60. If I'm not wrong, I will stand corrected. I searched it in the subsection 2, in particular and without prejudice to the generality of the foregone power. That's the general power, subsection 1. Then specific power. Such rules may provide for any of the following. Your lordships will not find either section 19 or section 60, except your lordships straightway come to K again. Any other matter which may be or is required to be prescribed. So again, the state retains. State can do it. Now, rules were framed, my lord, under section 106, subsection 1 and 2K. Subsection 1 covers 19, section 19. Board can control. My lord, state, the board's power, the power given. My lord, subsection K again 2, my lord, K and read with 1, again control 60. So by one rule, the state, my lord, state controlled both the inter-school transfer, inter-council transfer. So, my lord, the applicable only in the subsection sub-rule 2 doesn't govern the entire rule. Entire rule has to be read as a whole. Now, my lord, kindly see your lordships, the judgment cited by my learned friend. As a whole again has to be read, with both the judgment says.
Yes.
Now, paragraph 7, I am told, my lord, 5, paragraph 5 is not. Paragraph 5, probably your lordship, incompetency of the legislature. 7. It is settled rule of construction that to ascertain the legislative intent, all the constituent parts of a statute are to be taken together, and each word, phrase, or sentence is to be considered in the light of the general purpose and object of the act itself. Rules under the act. What's the object of the act? Carry out the purpose. So this is the way the authority has to do. Otherwise, ultimate result will be what, your lordships, unless this rule is not there. Suppose board is without any rule to transfer. They will do, my lord, anything. It will be, my lord, a capricious power, unbridled power to them. Secretary will do. If they like someone's space, he will transfer. If they don't like someone's space, he will not transfer. Will be. And your lordship probably finds that in some cases. Yes. Even in spite of the rules. So, my lord, that's why, your lordships, the very first few lines, my lord, says it has to be as a whole. When the rule 8 is again amended in 21, that means legislature intend to prescribe it. Otherwise, my lord, legislature is not, my lord, blind. One cannot delete everything. Then, your lordships, the title of the Madras Sales Act describes it to be an act, the object of which is to provide for the levy of a general tax on the sales of goods in the province of Madras, and the very same words are repeated in the preamble, which follows. The title and preamble, whatever their value might be, as aids to the constructions of a statute, and undoubtedly throw light on the intent and design of the legislature, and indicate the scope and purpose of the legislation itself. Probably my learned friend has relied upon only this part. But I again repeat it, your lordships, kindly consider. The title and preamble, whatever their value might be, as aids to the construction of a statute, undoubtedly throw light on the intent and design of the legislature, and indicate scope and purpose of the legislation itself. Now, read, my lord, if your lordship, my learned friend submissions, once the title says only applicable to the council, not to the board, the board cannot. that will be against the statute. Because Rule 8 specifically says it applies to both. It may be one of the component for interpretation of a statute, but not alone title of the act. Title the transfer. If your losses kindly see the title, application, that is, title is the transfer rules. Here says rule. Kindly see your lordships. These rules may be called the West Bengal Primary Education Transfer of Teachers, including head teacher rules. This has been framed. I have submitted your section 106.
On that
one-
your lordship got.
Spiral 141.
Your lordship got it 163 of that.
163. Yes.
Kindly your lordship the title. The rules may be called the West Bengal Primary Education Transfer of Teachers, including head teacher rules. Teacher has been defined. So if I go by the title, it applies to all. Now the application part, sub rule 2. These rules shall apply to teachers, including head teachers, for the purpose of a transfer from one primary school to another within the jurisdiction. Therefore, my learned friend submits, in case of power of board to transfer, this rule doesn't apply. Now see, this was framed in 2002. Kindly see Rule 8, unamended Rule 8. Inter-council transfer. In case of inter-council transfer, the council shall follow the principles and procedures of the board in accordance with the provisions of the Act. At that point of time, there was a general conditions. My learned friend has relied on 1991. By rules may be by of adoption. There are certain acts which can be made by of adoption. Suppose on another state act can be adopted by the legislature, but that should be an act of legislation. So that was incorporated. Now this was, therefore, all that I'm trying to say, inter-council transfer was governed by the rules from the very beginning. Now this was amended.
Process which was laid down in 2002 subsequently has been amended in
Exactly. What means that? It's a positive exercise by the legislature. Only by application clause doesn't control it. Now kindly see amended rules. Rule 8. While considering the inter-council transfer in accordance with the provisions of clause K19, the board shall mutandis follow the provisions of these rules. But the legislature knowing that, so your lawsuit has to clarify that this can't be. Because power is there of the state. There is no incompetency. Power is there under subsection 1 of 106 and 2K. Therefore, your losses, my humble submissions, if your losses, the very paragraph 7, it again says, it is to be read as a whole. We are before your losses because of this certain incongruity your losses at best say. Subsection subrule 2 of 1 says something, but express provision is there, what the board has to do. Otherwise, board can't do that. Because board's power under section 19 is subject to the general orders or specific orders. Orders means the rules. This is one, and another judgment. Now, paragraph, probably this is 2002, volume 2 SCC 318, paragraph 11, if I'm not wrong. Kindly consider paragraph 11. The interpretation, has you also got that one?
Para 11.
11. My learned friend relied upon paragraph 11. Kindly see. The interpretation to section 3 as noticed herein before, offered by the High Court, cannot possibly be adopted. Neither the statute can be read in the manner and fashion as has been shown down by the High Court. Appointment of the competent authority in terms of section 3 for carrying out the purposes of the Act is said to indicate the authority is administrative, and neither judicial nor quasi-judicial cannot but ascribe to a totally erroneous. the statute shall have to be considered in its entirety, and picking up one word from one particular provision and thereby analyzing it in a manner contrary to the statement and objects of the reasons is neither permissible nor warranted. Well, that's why I've taken a title of the act. Teachers of the primary school. It doesn't matter, title never says that is applied to the council or board. Application.
To another council.
And there's one council to another council. The once this I have submitted the same division bench initially said one thing, but the same when the rule was shown to the honorable court, the court took a different view. No, it can't be. That's I have given. No, just a minute.
Again, you will reply.
For this, my lord, I have to give the reply without showing any judgment.
Again, how you can reply? Then you came up with a new decisions which was
No,
not
no,
like
my
in
lord,
the
I am
first
not
instance.
telling
I gave Mr. Sanyal the opportunity
my lord,
to respond.
my lord, what I am on. But I have not come on any new decision. I don't know what my lord
Your lordships kindly consider the judgment I have given to your lordships. Saroj Kanti Bal. I have given a copy to your lordships. Today I do not have a copy. MAT number 114 of 2025.
Yes.
Section 4. Section 2, 3 and 4. That's why
Paragraph 2, 3.
Paragraph 2, 3 and 4. Sorry, my lord. At the first blast, its order appears to be cryptic, but after inviting the council representing the respect, we do not find any infirmity. Then your lordships, section 19. Quoted. That it's only the board can do. Under this rules is applied to the inter-council transfer. The same division. Because earlier this was not considered. Five lawsuits. Consider that. And why the rule is made, your lawsuit, that has been also said.
Yes, yes.
That is also said. Why the purpose of the rule? Why? That's my answer. I do not take.
Your lordship kindly take that 2002 rules.
This has to come to an end. Again, you will start, then it will be.
No, 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 my lord, I am not.
Conclude.
I am not.
How long this will go on?
My lord, this, my lord, if I say so, my lord,
No, Mr.
in respect of reply, there should not be any other reply or opposition.
Yes.
I'm just taking your
My lord, they said showing some provisions. I am showing that provisions.
Let me go through the provisions. What they are saying is correct or not.
My lord, your lordship kindly on that day, my learned friend does not, my lord, indicate today just the 2002 rules in proper manner. I am only showing your lordship that 2002 rules. It is entirety. If we think the first 2002 rules without any amendment.
But Mr. to be son and a senior advocate appearing for the petitioner. A board who concludes his response with regard to the two decisions, namely cited on behalf of the petitioners on the last occasion, that is AIR 1953, Supreme Court 274 and 2002 SCC 318. For orders in next week, next Thursday for orders under the heading order on the next week for orders. For orders on 24th, no 24th.
No, 26th power.
26th for orders. 11 কি আছে? 11 থেকে?
Yes, my lord.
254, my lord, I am appearing on behalf of the petitioner, affidavit of service, my lord. Kept on record as well as the court.
No, nothing.
Bill for it.
At least, my lord, we expect a minimum notice that your lordship has fixed at 12:30, my lord. I expect from my learned friend, my lord.
Notice you have not given?
Nothing.
He was present at that point of time. My junior instructor is that he was present when
I can remember when my learned friend mentioned the matter last week, your lordship, my lord, was rising and your lordship didn't, my lord, allow the, my lord, mention.
that was in the list itself, my lord. That was in the list itself. But this matter, my lord, no more res integra, my lord. Already, my lord, this matter decided in, my lord, in Akash Mandal matter, my lord, already, my lord, decided. Later on, my lord, in Shubhecha Samanto Porel, my lord, it is decided, my lord, to Akash Mandal, my lord. This matter, my lord, relating to one of the pursuing candidate is allowed in a TET or not, my lord. Already, my lord, decided, my lord. And this petitioner wanted the same relief, my lord.
Same.
Yes, the same, my lord. Exactly the same.
Yes.
My lord. And later on, my lord, another order first, my lord. Judgment good. Already. Already. Akash Mandal already decided.
I am appearing in the similar matters, my lord. My item is just after that. Your lordships in Akash Mondol, my lord, has given the benefit to all. Kindly comes to page 9 of your lordship's judgment. It is a finding, my lord. It is annexed in my petition. Mr. Samim has also handed over a copy of the same to your lordship, my lord. Kindly seize your lordship's findings. Internal page 9 of the judgment. Your lordship has been pleased to hold. Therefore, a person, lordship has, my lord, I may not reiterate it, my lord. That will be wasting the court's time, my lord. It is, my lord, after persuasive, my lord, hearing from both the sides, my lord, your lordship has been pleased to come to this finding. In page 9, paragraph 13. Therefore, a person pursuing any of the approved teachers education course is made eligible to appear for TET examination. So this finding of your lordship unchallenged is covering all. This has to be construed in rem. Now, my lord, kindly sees thereafter lordship holds in paragraph 16. Therefore, bare reading of the order as well as recruitment route is imperative that at the primary stage, the persons are required to have DED in special education for RCI approved institution and DLED with a recognized qualification certificate diploma from such and such. Hence, there cannot be any quarrel that a person, that is what I am trying to substantiate, that your lordship's findings are in rem. A person pursuing the aforesaid course can take part in TET examination. Therefore, this court is of the view that the petitioners having pursuing. So, therefore, in the script of this, after arriving at the findings in rem, thereafter, lordship, while directing part, lordship has been pleased to, my lord, take into account the case of the petitioners, obviously because the petitioners were before a lordship. Therefore, this court is of the view that having pursued the DED in special education courses under RCI approved institutions be allowed to participate in the TET examination to be conducted pursuant to notification. Accordingly, West Bengal such and such is directed to allow to submit applications. So far as the petition, these were my petitions and the petitions of another, my lord. In respect of other, my lord, in respect of Mr. Shamin's petition, some of the petitioners were not similarly circumstanced. So therefore, Lordship was pleased not to grant. But still, in this case, before your Lordship, we are all persons who are pursuing D8 in special education courses under RCI. So therefore, my humble submission is that, my lord, on 22nd, my lord, the date has been fixed for holding the TET examination. My lord, if your Lordship, my lord, these are only, my lord, now this order, your Lordship was pleased to pass on 2nd December. Now, my lord, in respect of these petitioners, since, my lord, these petitioners were my clients, my lord, we have the information to that effect that they were directed to fill up the forms last week. Notices for committing contempt had also been served. But in any case, since they have been allowed to fill up the forms, my lord, they are not before your Lordship because there is no contempt as of today. But point is that they had waited till the last week. That is last week when this matter was filed.
No,
When
why,
I
why
mentioned
they were waiting for that?
the authorities have waited for complying with the judgment of 2nd December. They have called, your Lordship's judgment was that it has to be done within as expeditiously as possible. Lordship kindly sees, accordingly, petitioners are primarily directed to allow the petitioners in such and such to submit applications through online offline mode. This was the direction, paragraph 18. This direction was complied with at a very later stage on 12th or 13th of February. So therefore, these are basically, my lord, if they want, they can do it. It is not that they cannot do it. So therefore, my lord, any delay that on the first occasion, my lord, I had mentioned, it has fallen from your Lordship that why are you coming at the delayed stage? But my humble submission is that, my lord, there is no delay because there are 1 or 2 months. There is that delay for filing 226 is very meager. Because 226 is guided by, my lord, the principles of limitation act, which is 3 years and all. But for this, when we are
You also keep in mind the last date of the
yes,
application.
acquiescence, estoppel,
Those petitioners for whom you moved the application
were
they were
prior to
waiting
the last
date
date.
of closure. Yes.
Yes, I understand. That is what has fallen from your Lordship. But in respect of, my lord, what we are seeking before your Lordship is an equitable relief. Now, my lord, for seeking an equitable relief, when your Lordship is exercising 226, my lord, this part of delay will not be, my lord, may not be considered because we have not, my lord, we have not, there is no acquiescence on any part. We have not said that we have not challenged, we'll comply with the thing. We have challenged prior to the happening. So therefore, my humble submission is that, my lord, the other persons also are similarly circumstanced and the findings of your Lordships are in rem. So therefore, it was the duty of the authority itself to, my lord, publish and invite persons in view of your Lordship's judgment. They ought not to have sat tight and not extend the benefit when they know. Point is that they have committed an illegality. Your Lordship was of the view that yes, this illegality has been committed. You are not being allowed appropriately. So therefore, it was for the Commission, being an Article 12 authority, to, my lord, call for the other similarly circumstanced persons to, my lord, give the to file, my lord, the applications who are, my lord, pursuing candidates. And, my lord, other points.
The notification was there showing that this is the last date for filling up the application.
Yes.
And that was
That notification, your Lordship has been pleased to interfere, saying that there was an illegality committed by the Commission at the outset when they have published the first notification, which was the point of challenge before your Lordship. Your Lordship has been pleased to hold.
Yes.
So therefore, my lord, my humble submission, my lord, subject
My lord,
to
may I add, my lord? My lord, kindly turn my writ petition, page number 59.
59.
59. What was the last date of this online application? 25th November 2025. That was the last date. If the board stand is that after last date, we will not give anyone's benefit. Kindly see, my lord, pass an order on 10th December 2025, my lord, which I handed over, WPA number 27624 of 2025. my lord, may I read the order, my lord? And that matter filed on 2nd December 2025.
That is the reason. That is the reason.
My lord, I
Look,
can.
I have seen. The
I
cutoff
can-
is 2nd December.
Yes.
That was what I was telling you.
No, my lord, with greatest
Once
of
who
respect,
has
my lord,
filed
the
the
last date.
petition prior to the date of closure, I have accepted them.
Extend এই দেখেন
Order is given on 10th December, my lord.
10th December, but since the writ petition was filed prior to on
No.
2nd December.
My lord,
না, না,
2nd December, my lord, that is the.
সেকেন্ড ডিসেম্বর
My lord, apart from that, my lord, what is the law, my lord? I just want to cite it to Apex Court judgment, my lord. My lord, earlier occasion also, the West Bengal Board of Primary
The
Education.
other order that was passed.
Yes, my lord.
না এইটা না এটা কত দিস আর
My lord, I just want to cite it, my lord, to Apex Court judgment in this regard, my lord. চুপচাপ দাঁড়াও। Please. This is a law, whether a pursuing candidate ought to allow or not. NCT TET conduct guideline says pursuing candidate ought to allow in TET, my lord. Who made this mistake? An Article 12 authority made this mistake, my lord. The Supreme Court stand is very clear in this regard. If an Article 12 authority made a mistake, what ought to step ought to taken by the authority if that is rectified by the court? But kindly take a judgment 2024 SCC online SC 3664. 2024 SCC online SC online page 3664. আমার বলা শেষ হলো তারপরে বলুন।
Paragraph?
SCC online SC 3664 para 14 and 15. May I read once? It is a well-settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his oblique her favor, others similarly situated ought to be extended the benefit without the need of for them to go to the court. An Article 12 authority made a mistake. They can't say that each and everybody ought to go to the court. Thereafter,
No, tell me one thing that after 22nd, this principle can be applied.
yes,
How?
because of that,
After
earlier,
22nd February, this is my question to you.
when
When it's not of similarly circumstance. If suppose an application has been closed, there is no dispute to the fact that the similarly circumstance should be, their application should be accepted. But if the date has been closed and you file later on after 2 months, whether what has been done by the board, that is not the issue. As far as your coming to the court is concerned, or your grievance is concerned, that is at the date when the publication was made.
with greatest of respect, my lord, with greatest of respect,
When
my lord,
the
what was the
application-
mistake? My lord, the paramount consideration is that, my lord, the mistake made by an Article 12 authority, my lord. If a court rectify it, then, my lord, other similarly situated candidate with an legitimate expectation that they will rectify their own wrong. My lord, in earlier occasion in the year 2022,
What-
my lord,
What
in
I
Minoy Sarkar matter,
I just want to clarify one thing that
Minoy Sarkar
they are similarly circumstanced. There is no quarrel of that. They are pursuing candidates. There is no quarrel to that. But say 22nd February is the last date, is the date for holding TET. On 23rd, a person comes up before the court and says that I want to participate in TET. You conduct the TET again. I am similarly circumstanced. Can that benefit be extended to him?
My lord,
There has to be a last date, which was known to your client that this is the last date. So if the board is not allowing, there is an order of this court, approach the court. This has been done in the month of February 2026.
May I give the
So
answer,
every-
my lord? May I give the answer, my lord, in my
Yes, yes, give that answer.
my lord, till date, TET yet not, my lord, conducted. The TET conduct date is 22nd, my lord. Till date, my lord, even up to tomorrow, my lord, the candidate whosoever, my lord, similarly situated, because the TET is not yet conducted, my lord. TET will conduct
on 22nd, coming 22nd. I have a legitimate expectation, being a citizen of India, that an Article 12 authority, they made a mistake, they are wrong, is rectified by the court, they will give equal opportunity to all the citizens. This is an TET, mere an examination, it is not an employment. It is a minimum eligibility criteria. From another thing,
consideration to be employed.
Yes, another one, it is, although this is in para 15, KI Separd is already quoted, 1987, 4 SCC, 431, para 19,
Give.
আগেরটা কি দেখি 4 SCC
Oh yes, para 15.
Para 15, it is quoted, I just handed over that para.
নাম্বারটা বল
1987, 4 SCC, 431, para 19.
for
May I read? Just it gives the my lord's queries and it gives the answer, May I read, The writ petitions and the appeals must succeed. We set aside the impugned judgment of the single judge and division bench of the Kerala High Court and direct that each of the 3 transferee banks should take over the excluded employees on the same terms and condition of employment under a respective banking companies prior to amalgamation. The employees would be entitled to the benefit of continuity of service for all purposes, including salary and perks throughout the period. We leave it open to the transferee bank to take such action as they consider proper against these employees in accordance with law. Some of the excluded employees have not come to court. There is no justification to penalize them for not having litigated. They too shall be entitled to the same benefit as the petitioners. Ordinarily, the successful parties should have been entitled to cost, but in view of the fact that they are going back to employment, we do not propose to take others of cost against their employers. We hope and trust that the transferee bank would look at the matter with an open mind and would keep themselves alive to the human problem involving it. So, a person not came to the court, for that reason, is penalized. The Supreme Court deprecated it.
Everyone cannot have access to the High Court. Well, everyone, it is a fact. Everyone cannot, they do not even think that we have to come to the High Court to get a job. Why a person will come to the High Court for getting a job? Now, because of this trend which is coming into state of West Bengal, that whatever is being done by the Article 12 authority is being considered, is being challenged. So therefore, it is there as of today, it coming. But point is that why the Article 12 authority is supposed to act in accordance with law.
Yes, Mr. Sandhu.
And my lord, another judgment, my lord, if it is there, my lord, one paragraph, may I just quote, my lord? This is, my lord, I'll just give the citations. 2008, 1 SCC. 2008, 1 is, no, this is not 2008. This is 2000, 2015?
উপরে তুলো না
Right, circle এটা হারিয়ে যাবে।
আরে ওখানে চলে আসবে
2015, 1 SCC 347, my lord. May I just read out, my lord? I'll give it. The normal rule is that when a particular set of
2015 volume 8 SCC
1, not 8.
2015 1 SCC 347.
Okay.
The normal rule is where a particular set of employees given relief by the court, all other identically situated persons needs to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. These principles needs to be applied in service matter more empathically, as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not treated differently. Now, the point thereafter, the Supreme Court goes into and says that it is well recognized, exceptions are there, delay and laches, acquiescence, everything is there. But the point is that here, these cannot be applied in view of the fact that we have come prior to the holding of the examination. That is why, that is my content. It is not that in this case the relief was denied because they have approached 9 years after the process. In this case, the case that I have cited before your lordship, it has denied. But it, on the ground that they have approached 9 years. But here, my lord, it is all the facts and circumstances of the case that your lordship has to, my lord, consider. That is my, and this is only because only I'll not get a job. I'll just get an eligibility to participate in the subsequent process. But this is only because of an administrative lackadaisical attitude, my lord, they are doing this. They have done this because one person in the office didn't knew the law. So therefore, it has been given and everything has passed up without application of mine. They will be opening a portal. One day it can be filled up thereafter. Man, it is not a very big deal that they have to rewrite the entire selection process. The selection process, we are doing matters before other courts also, where, my lord, even as of today, the selection process, the interview list has been done, counsel is being done. But, my lord, in any case, when the courts find that there has been some illegality, but they have to do it. And here it is not that they have to rewrite the, my lord, the panel. They have to.
Yes, my lord, I just show one notification from my writ petition, page number 84. In the year 2022, my lord, they made same mistake. And they rectified it and give the opportunity to all. My lord,
Yes,
kindly
yes, it
turn
was
page number
there.
84, my lord. Kindly turn
Get
from my
Baruch.
writ petition, page number 84. The same Article 12 authority, my lord, they made mistake, my lord. And thereafter, my lord, they, through an addendum notification, my lord, they add it. My lord, may I read, my lord? With the reference to earlier notification, video number such and such 29 September 2022, in regard to the condition of teacher eligibility test 2022 for classes 1 to 5 by the West Bengal Board of Primary Education, the WBBPE adds an additional eligibility criterion to the section 2 of the notification published earlier, video number such and such, adhering to the relevant content of the NCT letter, video number such and such, dated such and such. The added eligibility criterion shall be read as a last addendum in the section 2 as follows. And the person who have enrolled their name for pursuing 2-year diploma in elementary education by whatever name known, 4-year Bachelor of Elementary Education, BLED, and 2-year diploma in education, special education, recognized by the Rehabilitation Council of India, RCI, and Bachelor of Education, BEd, in any NCT recognized institution shall also be eligible to sit for the TET 2022. So earlier occasion also they made mistake. Now, my lord, repeatedly they made mistake, my lord. My lord, so every people ought to come the court. This is not the way, my lord.
May I take leave, my lord?
Yes.
Deep leave.
Give that judgment.
Yes, I'll just give the judge.
Oh.
My junior is giving the judgment, or if the book can be arranged.
No, my lord, my first submissions, findings of an honorable court, my lord, cannot be in rem. Application of the judgment can be in rem or can be in, my lord, in personam. Findings cannot be. Findings of the lordship judgment is applicable to the case ratio of your losses. Now, my lord, so many petitioners appeared in this matter. Your losses find the cause title 5 writ petitioner of the lordship's order dated December 12, 2025.
Yes.
Now, my lord, having heard us, your lordships, paragraph 20. It is made clear that this order will be restricted to the petitioners of the aforesaid writ petitions only, whose prayer for submission of the application allowed. So this is not judgment in rem. This is judgment in personam.
Yes.
So, my lord, after this judgment, on the last day of the filling of the form, this was allowed. Now, my lord, these writ petitions were filed even before 2nd December. It was taken up since the last date. That's your losses are being heard as point of law, whatever, but restricted to this. Now, today we are, your lordships, 19th February. 2 months more have expired from this. When we have allowed them, that's not the point, because I have to take certain steps for them also, because my portal was like that. Now, my lord, would your lordships find any explanation in the two writ petitions? Now, so far the similar benefit extended to death principles known to all. Now, the Supreme Court also comes up with this, that at belated stage, you can't say that is similarly benefit. My lord, I have not seen at least any of the judgments shown to your lordships that in respect of a cut-off date of an examination, that is over, but the similar benefit was given to all. I have not seen, none of the judgment is that. Kindly have a look at this judgment to them. The factual my lord, things are totally different. My lord, suppose somebody has been given pensionary benefit on these facts. Those petitioners came, they were allowed. Authorities restricted to them only. The Supreme Court says, no, you cannot, you give it to all. There is no cutoff, time limitation. Now, 2nd December, this is over. This is affirmed on 9th of this month. Tomorrow, day after tomorrow is the examination. How am I to allow them, your lordships? 22nd, my lord, December, February is the examination date scheduled. Sunday. Now, the board is also holding the other works, your lordships. Interview was going on for the selection process. So they can wait. But we proceeded, your lordships, to the restrictive views. This is applicable to them. There is no other candidate. How do I know, my lord, somebody wish to appear, somebody who is not wish to appear? So, my lord, my humble submissions, a person's, those are incompetent to apply now as of today. They are incompetent to apply because of the last date. Last date cannot be questioned, I believe, losses. So, having waited, no explanation, your losses. I have gone through, I will stand corrected if there is any explanation that because of this. And this was restricted to them. This was not the submissions that it should be open to all. So, you allowed us to proceed like this. I'm an authority also.
Yes.
So, at the belated stage, my lord, they cannot, my lord, do like this. Similar benefit cannot be allowed to them. And this is a restricted judgment. It's not a judgment in rem, it's judgment in person. Otherwise, the entire examination is to be stopped throughout the state. Just a minute. Kindly, your lordships, there are judgments because this was without notice, I am told, my lord, I am doing it, my lord. This judgment kindly take note of. There are judgment has come up. My lord, this is 2022, volume 1 SCC, page 335. My lord, my lord, if I get one day, I will give your lordships the judgment also. But any event, I am giving one because of this facility we are getting now. My lord, paragraph 12, kindly take note of that. In that background, my lord, I think your lordships, paragraph 11 should also be placed. Furthermore, from the
Just a minute.
process will get it. এই benefit I don't know. কোর্টে এসে বলছে ওরে বাবা
আপনি কেন চেনেন বাবা?
ওরে বাবা
জুনিয়র্স আর সাপোজ সিনিয়র্স আর নট আপনি কেন?
না না এটা ঠিক আছে ঠিক আছে 11 পেরিয়ে গেল মানে মে আই হ্যান্ড আপ
I'm trying to find out. Pankaj Kumar.
Just a minute.
Pankaj Kumar.
Pankaj Kumar.
Yes.
Well, I am relying upon paragraph 11 and 12. Further, from the very nature of consideration made by the High Court, it is seen that it was the casual attitude of the respondent which had brought about the situation, though the High Court has mildly put it as inadvertence and provided an opportunity. It is no doubt true that as contended by the respondent in the objection statement, an opportunity was granted to about 151 candidates to take part in the selection process, as indicated in the notice dated 14 January 2019, issued pursuant to the directions issued by the High Court in the writ petitions which were to be filed. It is to be noted that the respondent was not vigilant at the earliest point of time, but it is only after such consideration has been made by the High Court and opportunity was granted to certain other persons. The respondent has chosen to file the writ petition by merely contending that he had made a request to permit him to take part in the selection process on 15 January 2019 and had not been permitted. Even that fact is not coming forward before lawsuits here, the petitioner. Now 12. In that background, it is to be noted that another single judge of the High Court in a similar circumstance had dismissed the writ petition filed by one Radha Sharma seeking similar relief, and the said order was upheld by the division bench. The order of the learned single judge was dated 13 May 2019. In any event, though the indulgence was shown in the earlier cases, a line has to be drawn at some stage. This is my point, your lordships. Or otherwise, the recruitment process undertaken by the competent authorities would be meaningless without a timeline, and the next recruitment process will also get affected, since determination of the number of vacancies for the next process will keep fluctuating. The process herein has commenced in the year 2015. The document verification physical test was done such. Several can permitted to pursuant to the order taken part. Since sufficient time has elapsed thereafter, it would not be appropriate to make an exception in the case of the respondents at this stage, as otherwise the technique will continue. Kindly apply these facts of the case, your lordships. In that case also, your lordships, some 151 candidates were allowed. Someone came up and said, I had applied, but I was not allowed. But he came long after that time. Now here your lordships allowed all of them, restricted to them also. Everybody knew about it. The same set of lawyers appeared.
Lawyers will not read.
What I'm saying, your lordships, it's known to them.
Lawyers know the law.
So restricted application, we are allowed them. Now the date was over. Even the application was not filed within the time limit. But there are one sort of views, your lordships. If the application filed within time, your lordships, sometimes extends. I can give one example, your lordships. In Electricity Act, appeal has to be filed within 30 days. Supreme Court says no condonation. This court extended like this. If the final order of assessment questioned within 30 days, then your lordships finds the appropriate case, the delay, rest of the part is condoned and allow them to appeal. But how, your lordships? Tomorrow, day after tomorrow is the examination. One authority has to act. So therefore, my humble submissions, this should not be allowed.
With regard to my lord,
May I submit one thing? My lord, may I submit one thing, my lord? The only point with an Article 12 authority, I could say, my lord, it's a heartful submission for a candidate, because an Article 12 authority, my lord, made mistake in the year 2022. They rectify it through a notification, give opportunity to all in the year 2022. My learned friend says the same advocate, I could say the same authority, made mistake in the year 2025 again. They compel the citizen of India come to the court. Court rectify it. Then not extend the benefit to all. They compel other similarly situated candidate come to the court. Now, if the order not passed in the favor of that sets of candidate, that means that sets of candidate is penalized by an Article 12 authority as well as by the Constitutional Court. Early, and second thing is that, my lord, delay latches. My lord, in this regard, my lord, I want to, I second copy আছে my lord, আমাদের তোমার জাজমেন্টটা বের করো
কত কোন প্যারাগ্রাফ?
প্যারা 130
প্যারাগ্রাফ
cited authorities maintainability.
Mr. Laidi, your
My lord, para 131 of
My
SSC
judgment
judgment.
15. It is coming. Oh, you should we see it from there?
yes, 15,
Yes.
which paragraph you are in? 347, it is Arvind Kumar.
State of Uttar Pradesh versus Arvind Kumar.
Yes.
Paragraph 21.1. And 22.3. Here also, my lord,
বলো না
Judge Sahib জিজ্ঞেস করুন।
SSC judgment of
SSC কত নম্বর প্যারাগ্রাফ আছে?
para 131. My lord, because of that, my lord, in this, although my lord is well aware of the fact that 26,000 candidates, my lord, they got appointment thereafter after almost 7 years, my lord. That petition filed, thereafter, my lord, their service was terminated. Delay latches point was taken up, and that is dealt by this court as well as by the apex court. But the law is very settled. If an Article 12 authority made a mistake, the Constitutional Court, they take considered views thereafter, and Constitutional Court pass an order. In this core ballot, that delay latches must not come in the way.
Okay.
Because they made the mistake. Earlier occasion, they made the mistake. Thereafter, they rectify it. Again, they made the mistake. So it's an elaborate judgment, my lord. I'm not referring it, but I give the example, my lord. I could say, my lord, I can, my lord, cited the
Paragraph 145 he is citing basically.
That's all.
More judgments now on the same issue. I can
No, let us not go into, let us not go into that, my lord. Judgments will continue to come, my lord. Point that it has been argued that we have not applied and we have come to the court, my lord. Our contention is that, my lord, we have been held to be ineligible to be applied. So therefore, had we applied, even in spite of being ineligible, it would have been argued that, look, you have applied, so therefore you have admitted all the terms and conditions. Now, how can you turn around and challenge? So therefore, the point is that it is the appropriate stage of coming before this honorable court without applying. And that is the only thing, whether that application, whether this approach ought to have been prior to the last date of last cut-off date or after the last cut. That is the point that your lordship has to decide. But the submission made that we have not applied and have approached this honorable court is not right. That is all. Deeply obliged, my lord. Lordship has taken up the matter, my lord.
আইটেম নাম্বার গুলো বলে দিই নাকি?
এটা রাখুন, আমি ফিরে এসে
তিনটে আইটেম, তোমার নাম্বার কত? আইটেম মানে আইটেম নাম্বার 254, 255 is mine, আর তোমারটা কত?
256.
256 is mine, other friends.
54, 55 you.
Yes. 256.
After I come back, I
Deeply obliged.
আসুন। Please file the affidavits of service in all the matters.
Yes.
Affidavits of service, affidavits, service, এটা তিনটে একসাথে করবেন। 254, 255, 256.
But I am appearing for state in item 256.
আচ্ছা,
এটা 255 এর affidavit of service. 254
affidavit
একটা
of filed on behalf of the petitioners is taken on record. The petitioner in by the writ petitions, the petitioners have sought for directions to allow them to participate in teacher eligibility test within bracket in short TET, which is to be conducted V-Day memo number 2061/WBBPE/2025/60 R-09/25 dated 15 September 2025. All the writ petitioners are pursuing courses approved by Rehabilitation Council of India within bracket in short RCI bracket close for special education as required for appointment to the post of special educator teacher in primary schools. Mr. Firdos Samim, learned advocate for petitioners in WPA P198 of 2026 and WPA 3203 of 2026, submits that the pursuing candidates have been allowed by this court to participate in the TET examination pursuant to notification dated 15 September 2025. In other writ petitions, V-Day order dated 12 December 2025. The 2nd December 2025. 2nd December. The petitioners are similarly circumstanced. As such, they be allowed to participate in the TET examination. Although the writ petition has been filed after the, what was the last date? 2nd December?
2nd December.
After the last date of closure of the application, that is 2nd December 2012. However, 2025, however, such aspect would not restrict the authorities to accept the candidature of the petitioners to participate in the TET examination. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in Lieutenant Colonel Suprita in 2024 SCC Online SC 3664 and A.I. Shepherd and others versus Union of India, reported in 1987, Volume 4, SCC 431. Mr. Onindo Laidi, learned senior advocate, appearing for the petitioners in WPA P210 of 2026, in similar breath, submits that since the petitioners are similarly circumstanced and the judgment of this court has been passed in rem, the judgment of this court is a judgment in rem, it applies to all the persons similarly circumstanced.
Findings are in name. Ordering part, it is not in name. Findings.
Fine. Findings further. Judgment in rem in the findings of the court. As such order of the court applies to the petitioners who are similarly circumstances, irrespective of the fact that the writ petition has been filed belated. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in 2015, Volume 1, SCC 347.
Yes, this is the copy, my lord.
347. এখানে একটু বলে দিই।
Paragraph 22.
22.3.
22.1, 22.3.
হ্যাঁ, ওটার আগে একটু বলুন। The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending the same benefit. To buttress his contention, he relies State of Uttar Pradesh and others versus Arvind Kumar Srivastava and others, reported in 2015, Volume 1, SCC 347. আচ্ছা, টপে না আচ্ছা দিয়ে দিন সাপ্লিমেন্টারি অ্যাফিডেভিট ফাইলড ইন WPA 3210 of 2026, the leave grant করে এটাকে অ্যাকসেপ্ট করে দিন। On the prayer law learned advocate for the petitioners in WPA 3210 of 2026, leave is granted to file supplementary affidavit. Supplementary affidavit filed by On the contrary, Mr. Subir Sannal, learned senior, you have the hard copy of that judgment?
I've just
Subir Sannal, learned senior advocate appearing for West Bengal Board of Primary Education, hereinafter referred to as the board, bracket close, submits that the petitioner has filed the writ petition seeking for similar relief after almost 2 months of closure of the last date, closure of the application. On 2nd December 2025. There is no such plausible reason for such delay being depicted in the pleadings in the writ petition. Since the petitioners have approached this court at a belated stage, such prayer for participating in date cannot be allowed. To buttress his contention, he relies on the decision of again. Honorable Supreme Court passed in state of Uttar Pradesh versus Pankaj Kumar and others, reported in 2022 volume 1 SCC 335. Oh. Upon hearing the learned advocates for the respective parties, the only issue which falls for consideration is whether the petitioners, being similarly circumstanced as that of the petitioners in the earlier writ petitions, be allowed to participate in the ongoing state examination or not. Admittedly, the last date for filling up of the application for participating in the TATE pursuant to the notification of dated 15 September 2025 has already elapsed. Stop the date being 2nd December 2025. Some of the candidates approached this court in WPA 27540 of 2025 and other batch of writ petitions wherein this court has directed the board to allow the petitioners to participate in the TATE examination. Thus, from the facts as noted herein above, it is found that the writ petition being filed. What is the date of your filing? Yours is 9 February. Yours is 9.
Mine is 9.
Writ petitions have been filed on 9th February 2026. That is after almost 2 months.
Sorry, 9th.
The Honorable Supreme Court in the decision of Arvind Kumar Srivastav Supra observed as follows, para 22.1, 22.2. Just it out, huh? In Pankaj Kumar, the Honorable Supreme Court, in paragraph number 11 to now, para 11, observed as here under. in the decision of Lieutenant Colonel Suprita Chandel, Supra, in para 16, it has been observed as follows. 16. Therefore, from the aforesaid proposition as laid down by the Honorable Supreme Court, the principles that the normal rule that a particular set of employees be given relief by the court, all the other identically situated persons need to be treated alike by extending that benefit, cannot be disputed. Be that as it may, where there is exceptions, where there is delay in approaching the court, and at the same time bearing in mind that the last date for filling up the application form has already elapsed, the petitioners cannot be extended the similar benefit. In view of the above discussion, the writ petitions fall short of merit. Accordingly, the same is, in the judgment of this court, in para 20, it has been categorically mentioned that the order will be restricted to the writ petitioners only. In view of the above, dismissed.
My lord, my affidavit is in the way, my lord, it will come. I'll give it.
Okay. Ask your junior to submit that.
Yes, yes.
Thank you, sir.
Urgent plain copy, my lord, because of
Urgent certified copy is applied for. What are the date there?
plain copy. Plain copy, my lord. Plain copy, my lord. Otherwise, my lord, 22nd is that date of examination, my lord. Then unless I get a copy, my lord, important right, my lord.
Without the copy, also certified copy, you can file appeal?
No, plain copy. I ask for, because if that is not, because
Okay.
tomorrow is the last working day.
There is no plain copy.
Now, appeal can be filed with the website copy also.
Yes.
Then what is the difficulty?
There is no. If
How
by
parties to act
today-
on the server copy of this order?
Another point was in my submission, my lord, was that, my lord, in the year 2022 they made.
In
my lord,
the
can
year
you record?
2022, the board made a notification. Board made a notification to
Page number
allow all the candidates pursuing a particular course. Thank you.
Because they have
Owner, sir.
made the mistake in the year 2022 also, thereafter through an
Okay,
addendum
they-
notification,
Okay.
they rectify it and give
Okay.
benefit to all. They made same mistake, and for their mistake, the petitioner are penalized. Get load.
Hearing it to the
petitions are there.
one is by the
One is by the District Primary School Council,
One
Howrah.
is by us, and second one is by us, the District Primary School Council. And the first one is 258.
But there is, my lord, mine is in the year 2025. There is otherwise earlier in the time. My lord, I really is the aggrieved party because, my lord, I am the incumbent, my lord, who is being deprived of the benefits. চেষ্টা করছি। অসুবিধার একটু ইয়ে আছে, বুঝতে পেরেছি। ঠিক আছে? একটু তোমাদেরটা আমি, my lord, here, my lord, one confusion, my lord, on their part also, our part also. My lord, their petition is earlier, challenging the order of the appeal committee. Now, I am বলছি, my lord, so far their petition is concerned, my lord, I have a point of demur, point of maintainability. My lord, so far my petition is concerned, my lord, it is limited to only 3 charges. The point that, my lord, it should not have been remanded because the law doesn't permit remand. Only 2 avenues that has been given open, my lord, only either of the 2 should have been opted for.
Either allowed or rejected.
Either, yes, either reinstated or, my lord,
Rejected.
there are, yes, my lord, there are the parameters prescribed under Regulation 9 of the Appellate Committee Regulation 2012. Now, my lord, I am on that. My lord, first I think, my lord, their petition has to be taken up. With, my lord, my point of maintainability as a point of demur. Because, my lord, they have challenged in its entirety. My lord, I give your lordship, my lord, the brief fact. Then, my lord, why the point of maintainability I'll address on 2 judgments of the Honorable
In their
Supreme
writ
Court.
petition, you have filed your affidavit.
Yes, I have. My lord, so far my writ petition goes in spite of 2 directions. They haven't, my lord, probably because, my lord, 2 writ petitions are, my lord, dealing contradictions to each other. And it can be treated probably in that assumption, my lord, that has not been. Now, my lord, here in this case, my lord, there were.
Kagos din.
Lordship kindly takes up their writ petition first. My lord, the item 258, my lord, that is.
Yes.
It seems to be very voluminous. এটা কোনটা গো দাদা? আমাদেরটা। আমাদের 2019 প্লেস করছো আগে। On the point of maintenance. আচ্ছা। But I give you lordship, lord, the brief dates and the facts.
But let my learned friend conclude today, my lord, so far the maintainability of our writ petition as well as, my lord, the merit of his writ petition. But we will, my lord, answer your lordship, the answer to my learned friend the next, my lord, when your lord.
But he has to make submissions with regard to the maintainability of your writ petition as well as the merits of the other writ petition.
His writ petition.
So that will be an opposition to this writ petition.
Actually. Because, my lord, here, my lord, let me give the fact, the dates, and, my lord, then I'll straightway come to the points. Because it has to be, my lord, lordship knows, my lord, my argument before your lordship so far their writ petition will be. Why? My lord, lordship knows, my lord, the Honorable Supreme Court has on repeated occasion held disciplinary proceeding, inquiry committee, then, my lord, disciplinary authority. They are entitled to deal with the evidence. Appeal committee entitled to deal with the evidence as first appellate court. My lord, the Honorable Supreme Court in dealing with, my lord, the order of appeal committee cannot act as a second appeal court. No appreciation of evidence in that sense, accepting the parameters that has been laid down in Guna Sankar's case. My lord, that I'll be relying on. Now, my lord, here, my lord, in this case, my lord, I joined the service, my lord, in the year 2003. My lord, precise date is 29th August 2003. My lord, in his writ petition, my lord, I am respondent number 1. Opinion? File line? Lord, may I file the affidavit in opposition in it to D. And, my lord, so far my writ is concerned, my lord, the service. Notice. Now, my lord, 29th August 2003, my lord, I joined. That is, my lord, my opposition.
You are not filing any reply to this? Not required.
We have not yet filed. My lord,
Lord, twice direction has been given. My lord, I don't think, my lord, they.
Okay.
Now, my lord, 3rd May 2012, I joined that school, my lord, in 2003. 3rd May 2012.
No, what is the date of joining once again?
29th August 2003.
2003.
3.
Yes.
But I was discharging my duties as assistant teacher. Then, my lord, 3rd May 2012, my lord, I was appointed as head teacher of the school. My lord, on 8th August 2013, my lord, kindly sees, my lord, May and 8th August 2013. Hardly, my lord, not even 1.5 years, my lord, my discharging function as teacher in charge or, my lord, the headmistress of the school. My lord, a complaint, I say, my lord, purported complaint by 6 persons claiming to be teaching and, my lord, non-teaching staff, my lord, was made before the District Primary School Council, alleging various discrepancies in managing the school, such as, my lord, not consulting in taking decision with the other teaching staff or, my lord, non-teaching staff of the school, disposing of, suppose, my lord, a almirah was disposed of, and out of that money another furniture was purchased. My lord, these are the type of charges, my lord, on which, my lord, the complaint was made by 6 persons, my lord, who remained untraced till completion of the disciplinary proceeding. None of them came forward in that sense. Now, my lord, this was taken up by, my lord, the District Primary School Council as a preliminary inquiry, my lord, on the basis of that complaint. That was held before the authority itself. I participated. I gave my explanations there. My lord, they were not satisfied. My lord, the disciplinary proceeding was initiated. Inquiry officer was appointed. They found, my lord, all the charges established. My lord, held me guilty. My lord, dismissed me from service with stigma, stricture. That, my lord, no future service, my lord, like this. Now, my lord, I preferred an appeal. My lord, appeal committee took up, my lord, that, my lord, the finding of the disciplinary authority and the inquiry officer. If your lordship kindly comes to, my lord, the order of the appeal committee, if your lordship is there brief, my lord is pleased to take up. My lord, this is at page 83 to 119. Well, that is my appeal. My lord kindly comes to, my lord, page 136 to 159 of, my lord, this paper. 136 to 159.
No, this has not been filed. This paper book has been filed.
This is what has been served on us.
Definitely. Paper book আছে নাকি? এটা কোনো paper book আছে?
I believe there is no paper book.
No, the read petition.
Paper book. দাদা এই পেপার বুকটা কি আমরা সার্ভিস করিনি বলে?
পার্থপ্রতিম মুখোপাধ্যায়, I have been given this brief.
দেখি এটা কোনো অর্ডার আছে না?
পার্থপ্রতিম মুখোপাধ্যায়।
ওটা কি পুরোনোটা? ওটা পুরোনোটা? দেখি দিন তো।
Is there, my lord, any? This is a change brief. I tell you, lordship, my lord, that's why maybe a confusion.
So far I cannot recollect, I have not filed any paper book.
ওটাতে আমাদের কি বলবো আছে, ওটা নিয়ে আমাদের বেশি মাথা খারাপ করে লাভ নেই। My lord kindly takes up, my lord, my opposition. My lord kindly takes up my opposition. It will
we
be
just relate to the writ petition page numbers to
Lord?
find out the pagination in your paper book, whether it is matching or not. Then it will be convenient for you.
My lord
as
has
well.
also got the paper book.
It is not the paper book, it's the writ petition with the annexures. The volume itself shows that I think the paper book is the
My lord,
writ 140 you refer to.
no, probably, my lord, it won't match. Finding of the appeal committee, so far, my lord, this one is concerned.
Yes.
Photocopy of the order
532 to 555. My brief, the writ petition Page 530 to 555 is the order of the appeal committee.
Yes. Yes. Well, Lordship, can you take up, Lord, my opposition itself? Lord, it will be easier. Lord, this is less voluminous because those documents, Lord, we are not supposed to go in. 136 to 159. What to the 136?
Yes.
Now, my Lord kindly straightway comes to my Lord paragraph 14 onwards, my Lord page 140.
Yes.
May I place it? May I place it from there? Respondent number 1, namely Chairman, District Primary School Council, Howrah, entered into appearance through his learned advocate and submitted a written objection to the application of appeal filed on behalf of the appellant, wherein he denied it. States as follows: appellant avoided supply of documents to her in spite of repeated requests. Lord, I don't think, Lord, these are, Lord, in that sense necessary. Lord, you kindly straightway comes to, Lord, page 142, points for determination.
Yes.
Here it is precise and correct. It says whether the rules of principle of natural justice and fair play were complied with by the disciplinary authority, as well as the inquiry authority with a notice of reasonable certainty, whether imputed order of dismissal is valid and legal in accordance with the present law. On these 2 points. Now, my Lord, in the instant case, the primary teacher, my Lord, these are the charge sheet. My Lord, Lordship kindly. Then, yes, this is relevant. My Lord, paragraph 2 onwards, kindly allow me to place. The delinquent, being the head teacher, took various decisions whimsically in financial matters. My Lord, kindly sees. To purchase and exchange movable property without any prior permission of the competent authority and without consulting the others. This is one. The delinquent opened multiple bank accounts without any prior permission from her authority and did not record all the transaction into the cash book regarding the said bank accounts, and some outsiders were allowed to withdraw. This is allegation. The delinquent did not maintain the register relating to sale of admission form, bill register for collection of fees, neither formed any committee relating to collection of admission fees from the student on various heads, which is strictly beyond the rules. This is third. The delinquent made several misconducts, withdrawing money several times without any discussion with other assistant teachers. Whether the money has been misused is not the allegation. Allegation is that a delinquent made several misconduct. What is the misconduct? By withdrawing the money several times without any discussion with other assistant teachers. They are imposing a condition as if headmistress of the school, whenever for the purpose of the school has to withdraw money, has to discuss with the assistant teacher. And on that ground, there has to have a law supporting that. Now, this is what has been the ground of one of the charges. Then 5. On verification of teachers' attendance register from 2011 to 2013, together with resolution and replies given by the delinquent in hearing dated 18th August 2014, it reveals that she had made false statement without any hesitation, and this factual aspect. I will not ask your lordship to venture into this. Then delinquent had collected admission fee. This is documentary apparent. Lordship may the admission fees on different heads from 2011 to 13, 170, 190. My lord kindly takes note of these quantums. 200, 220 from several classes, namely from class 1, 4, violating the norms without taking any such permission from the competent authority, and no register was maintained for that purpose, and thereby delinquents had committed serious misconduct by violating the rules of primary education, being a head teacher. the delinquent made interpolation of original amounts in several fees, bill books, malafide intention to show reduced amount. She had committed a serious misconduct of defrauding and cheating the school as well as guardians of the students of the school. Below, no quantum is mentioned. Lordship knows, in case of fraud, defalcation of fund, particulars of account has to be given. Otherwise, my lord, the defalcation of fund cannot be established. My lord, here all the time what they are saying, my lord, nowhere, my lord, that particulars of account is given in, my lord, the charges or head of the charges. Excepting, my lord, that 6. My lord, then lordship kindly comes to, yes, 8. It appears from the resolution book 11th March 2011, 13th January 2012, adopted in Mothers Teachers Association relating to collection of fund from the guardians of the students of the school, and none of the teachers, including the delinquent, had signed the resolution on 11th March 2011, and only one teacher, being the convener, signed the resolution dated 13/1/2012. And it was presumed, my lord kindly sees, that the delinquent, being the teacher in charge of the school, went beyond the guidelines of Sarva Shiksha Mission and made assistance to adopt such resolution against the will or desire of the existing teachers. Will and desire of the existing teachers. And that had constituted serious misconduct. Serious misconduct is, my lord, the will and desire of the assistant teachers, my lord, not of the law. My lord kindly sees, all the time this complaint that has been mentioned is will, desire, and not consulting with the assistant teachers. This is forming the basis. Then 9. It appears, my lord, I could have straightway take your lordship, my lord, to the point of law. But, my lord, I need to place this because on what premise they proceeded. It appears from the so-called notice vide memo number such and such dated 12 December 2013 together with a memo number such and such dated 24th December 2003 issued against the delinquent from the office of the Additional District Magistrate Howrah with respect to the incomplete construction work of head teacher's room and girls' toilet and refund of allotted fund of 3,64,000. My lord, this has been satisfied, but again, my lord, this is, my lord, with regard to a fact-finding portion. Then, my lord, 10, on verification of the entire 10, my lord, at the bottom of that page. On verification of the entire documents furnished by the delinquent, fee books as mentioned in para 8 in a reply dated 21st October 2013, and after comparing with the cash book from 2011 to 2013, it appears that delinquent had collected admission fees annually from the students to the tune of rupees 1,88,000 only, but on meticulous verification of the enrollment and admission register, the actual amount would be 3,05,000. And thus there was a shortfall of 1,12,170 only. And thereby it appears that the delinquent had misappropriated. Then, my lord, on 11, on verification and checking of the cash book with all bills and cash memos as submitted by the delinquent being enclosed with the reply dated 21st October 2013, it reveals that the delinquent had misappropriated another sum of rupees 1,03,365 only, as you did not furnish any bill or any voucher relating to the said amount. The total shortfall of amount is this, 2,15,000. The preliminary report submitted by the Additional Inspector of Schools P. Howrah and Sub-Inspector of Schools Southern North Circle Howrah against the delinquent has corroborated the aforesaid charge. These are the charges on which those were also taken into consideration by the appeal committee. My lord, the disciplinary proceeding was initiated on these charges. My lord, the finding of the committee charge-wise, my lord kindly comes to straightway. Now the rest is, my lord, dealing with, my lord, the submissions made. Their finding starts from, my lord, page 147. I am giving your lordship, my lord, the bare minimum that is necessary. (147), my lord, of my opposition.
Yes.
Perusal of the report of the inquiring authority, it appears that besides the narrations of the proceedings, he gave findings on each charge. Now let us consider the finding of the inquiring authority on each charge with reference to the charge sheet framed by the disciplinary authority as follows. With reference to charge number 1, it appears that the inquiring authority held the charge as proved, relying upon the hearing sheet dated 18th August 2014. My lord, this is, my lord, this informal hearing that took place, my lord, at the office of DPSC Howrah, which was pursuant to, my lord, complaint filed by those 6 persons. My lord, I had to be there. My lord, I was not aware of initially about the complaint. Copy was not served upon me. It is only when, my lord, fact-finding committee went to the school, I came to know about this. Later, my lord, I came to know about that complaint when, my lord, the hearing took place. That hearing.
My lord, I prefer one indulgence. Other matters be released, my lord.
Which other matters?
Other matters from the daily list.
I don't think because I will be addressing your lordship on point of matter. They may be released, my lord, for half an hour.
And again, the reply, Mr. Sannal, where is
The next week, Mr. Sannal, leave.
Oh. এমনি তো 3টে থেকে কি আছে? Just wait for some. 3টের সময় কি আছে নাকি?
তোমার রিপ্রেজেন্টেটিভ প্লেস
হিয়ারিং আছে? আরো?
এটা বলে দিলে ওটা রাখি। আমার তো ওখানে খুব লিমিটেড।
হুম।
বলছি যে তাকে বললাম
চিলিয়ে দিলাম নাকি? যেভাবে হবে। ঠিক আছে। পরের ম্যাটার্স গুলো আছে। Yes. Other matters are released.
My lord.
May I? 147, my lord, I was placing, my lord, paragraph 11 with reference to, my lord, that paragraph 11 subclause 1. My lord, with reference to the charge number 1, it appears that inquiring authority held the charge as proved, relying upon the hearing sheet dated 18th August 2014 and the hearing held by him. It appears from the daily order sheet number 6 that the said hearing sheet dated 18th August 2014 was marked as Exhibit 1. On production of the same on behalf of the disciplinary authority, it appears from charge sheet that the said imputation was framed on the basis of question number 42, 43, 43 of the hearing sheet dated such and such, and the inquiring authority did not proceed to make further inquiry to ascertain the nature of the fund out of which the Almirah was purchased. It's not that, my lord, any defalcation for personal use. Almirah was purchased. And whether any permission of the competent authority was required to make such purchase, and it is not also clear that besides the hearing sheet dated 18th August 2014, on what other evidences he relied on to assess this part of the imputations. So far, the rest part of the imputation is concerned, there is no breach between the obligation or duties mentioned in the said conduct rules and the imputation, and therefore the inquiry of the inquiring authority is incomplete and improper. So far, this particular charge is concerned. My lord, this is charge 1. With reference to, so it was incomplete, improper. My lord, there was no law, my lord, supporting the charge that was framed. My lord, that is the finding. My lord, kindly keep this in mind because this has been remanded, which is, my lord, under challenge in my writ petition, charge number 1.
Okay, since you are stating which of the charges have been remanded, that you indicate which of the charges have been.
I am straight away giving you, lordship. My lord, charges are, my lord, 1, 1, 2, 4, 7, 10, and 11.
1, 2, 4,
7, 10, and 11.
7.
This is the limited scope of my writ petition. 1, 2, 4, 7, 10, and 11. That is what they have said.
Number of charges was
12.
12.
12. Out of 12, 6, the appeal committee found to be absolutely unsubstantiated, having no basis in law, like this purchase of an Almira. 1 that has been remanded, saying that it was incomplete, no further evidence was taken. But at the same time, it has been observed that there was no law in the conduct rules wherein a headmistress requires to take permission from the higher authority for the purpose of purchase of any furniture for the school. Allegation is not for that the money I usurped. Allegation was that the Almira was purchased but without any permission. Question was whether it was at all necessary. The finding is that no such law was ever prescribed or placed before the appeal committee that a headmistress requests to have a permission from the district primary school council for the purpose of furniture for the school. That is the finding. In spite of that, it has been remanded. That is one of my grievances. 1, 2, my lord has been taken note of. 1, 2, 4, 7, 10, and 11 will be the focus of my submission. So far, the merit is concerned. Then 2, with reference to the charge 2, page 140, it appears from the report that the inquiring authority held the charge as proved on the basis of the statement provided by the Indian Bank. On examination of imputation, it appears that the same has 2 parts. One, based on the allegation that she opened multiple bank accounts without any prior permission from the authority concerned. And the second part spells that she did not record the transaction in cash book with regard to the account lying in the Indian Bank. And she also allowed some outsiders to withdraw some amounts from the said bank account without any explanation. It appears from the report itself that the inquiring authority did not perform any inquiry regarding the first part of the imputation. So far, the second part of the imputation is concerned, he relied on the bank statement. But he did not make any inquiry into the nature of transaction recorded in the said statement. And in absence of such inquiry, this is very vital, it cannot be ascertained that the delinquent had allowed the outsiders to withdraw any amount from the said bank account illegally. It is also, this is in addition to that, my lord, pausing here, my submission is, here is also, no charge, no finding that even if the amount was, withdrawn for argument's sake, not admitting, that was misutilized or misappropriated. That allegation is not there. Withdrawal allegation is there. I have taken instruction, the explanation that was given, on that particular day, she was not keeping well when the money was required. She handed over a bearer check to her own husband for the purpose of withdrawal, which was the money withdrawn but used for the school itself. Used for the school itself, not for personal, because it was specifically on that day it was required. That's why it had to be withdrawn by a bearer. Now, that is only for the purpose of explanation before your lordship, but it is not there on record.
But then in the written statement also, you did not state this fact that the husband was given a bearer check to withdraw on the said date? No.
I'll check and come, revert. So far I can recollect, it's probably not there. It's probably, I took at the time of conference that what happened, that's why. But I cannot deposit before you. Therefore, in our opinion, the inquiry on this charge is incomplete and the conclusion arrived by the inquiry authority is perverse and bad. These 2, 1, 2, has been remanded. Then, I leave it, I'll concentrate, so far the charges are concerned, 4. Lordship kindly comes to 4. It appears from the report that the inquiring authority held the charge as proved, relying upon the hearing sheet dated 18th August 2014 and the hearing made by him. On perusal of the charge sheet, it appears that the said imputation is based on question number 42 and 43 of Exhibit 1. So the entire thing is on the basis of that Exhibit 1, taking that to be gospel truth. it is not clear from the report of the inquiring authority that on what other evidences he relied besides the hearing sheet dated 18th August 2014. The withdrawal of money cannot be a ground for misconduct unless there is a trace of evidence that the said withdrawal was detrimental. Here is the finding that said withdrawal was detrimental to the interest of the institution, and who were the authorized signatories, and no inquiry has been made on those issues, and he came to a conclusion on insufficient evidence, and therefore, in our opinion, the inquiry is incomplete and the findings arrived at by the inquiring authority is predetermined in nature and in law. Milord, this is very vital. Lords, you kindly keep this in mind and Milord, take note of this. Predetermined and Milord, bad in law. Milord, this is the finding by the appeal committee itself. Milord, the appeal committee has found in dealing with charge 4 that Milord, the inquiry authority, disciplinary authority, they were predetermined. Their action was prejudicial to me. Then Milord, 1, 2, 4, and then 7. Milord, at 152. With reference to charge number 7, 10, 11, inquiring authority held that the delinquent guilty of those charges. For this purpose, he relied upon the bill books, cash book, admission register, bill vouchers. Imputations of manipulation on the bill book used for the purpose of collecting of fees together with misappropriation of amount of rupees 2,15,000 only were leveled against the delinquent. Striking out of a figure or a phrase on any document itself does not constitute any misconduct unless it is done with an intention for unlawful gain. In the instant case, admittedly, there are some instances of striking out of figures on the bill books which were used for collection of fees containing the signatures of the delinquent. It is admitted by the delinquent during hearing dated 18th August 2014 that whatever collection was made was deposited in the bank account. But to determine these three issues, no statement of reconciliation of amount shown in bank passbook, cash book, and amount collected through bill book was placed on record. In the instant case, it is admitted position that no separate register was maintained for collection of fees, save and except the bill books and following the principle of rule of best evidence. The bill books are basic documents to ascertain the total volume of collection. And in order to ascertain the amount of misappropriation, it is required to reconcile with the bank statement to ascertain whether the entire amount collected was deposited in the bank account according to the admission of the delinquent. And the question of misappropriation arises if any difference is found in between the collected amount and the amount deposited in the bank. On perusal of the report of the inquiry authority, together with the materials placed before us, we do not find any clear indication that amount collected was ascertained following the rule of best evidence, and inquiry authority relied upon the report of preliminary inquiry where the entire collection was ascertained on the basis of the admission register. It further appears from question number 27 of Exhibit 1 that it was resolved by the resolution dated 30th September 2010 that the account of fees collected from the guardian was to be maintained by the committee of 3 persons comprising of head teacher, 1 assistant teacher, and 1 Kobita Banerjee, guardian representative. And therefore, if any misappropriation is detected, not the delinquent alone, my lord, kindly take note of this, but all the 3 members of the committee were collectively accountable for the same. And in that case, if it appears to the disciplinary authority that the same amounts to a misconduct, he is to proceed simultaneously against the head teacher and the assistant teacher who was also the member of the committee. In the instant case, the inquiring authority neither inquired into the fact that who has entrusted the fund with the delinquent, how it was to be managed, who were responsible for keeping the accounts of the fund, and therefore the inquiry on this issue remains incomplete and no inference can be drawn on the basis of such incomplete inquiry based on incorrect evidence, and therefore we are of the view inquiring authority came to a misconceived finding, ignoring the rule of best evidence and the other relevant facts associated with this imputation, and the same is perverse and bad in law.
This collection of fees,
Yes.
the cause of action of collection of fees, this starts from which date?
Milord, that
It
has
says there was a resolution.
nothing. Milord, if you lordship look into Milord charges 7, 8, Milord 7, 10 and 11. Milord, that has been Milord dealt with Milord in this set. 7, 10 and 11. Milord, no specific. That's what Milord I submitted before your lordship. That Milord quantum with particulars. Quantum with particulars. Milord, like Milord in CPC in case of a money claim, particulars are to be given and particular quantum has to be given.
Yes.
Milord, the same here applies. Nothing. Milord, if I place those charges, if your lordship so pleases again, I can get back to 7, 10 and 11. Milord, nothing. Only on that point it should have. Milord, this is
No.
absolute.
It says that.
Yes.
You come to page
143.
153.
150.
The paragraph start with, it
Yes.
further appears from question number 27 of the inquiry report he is referring to, Exhibit 1, that it was resolved by resolution dated 30th September 2010 that the account fees collected, there has to be a committee of these persons.
Mine.
And also it finds that it should not be initiated against the head teacher only, the assistant teacher is equally responsible if such amount is collected.
Correct.
My question is that what is the charge of this having defalcation or any sort of collection been made without authority by the headmistress? What is the cause of action? Which period to which period this collection has been? Is it prior to 30th September 2010? Why this resolution has to be adopted?
Milord, this resolution, Milord, for the purpose of working of the committee for the collection of the fees. Now, Milord, Lordship kindly take note of the fact that's why at the very beginning I said, Milord, I was appointed, Milord, as head teacher, Milord, in the year, Milord, 2012.
Oh, yes.
2012 and Milord, 2013 itself, Milord, the Milord proceeding was initiated. So 1.5 years I can be taken to be responsible for that, if at all.
This resolution is prior to your becoming a head teacher.
I was not at the helm of affairs at that point of time. But Milord, the period during which Milord I discharged, Milord, the function as a head teacher, Milord, my appointment as a head teacher was 3rd May 2012. Milord, this complaint was initiated on 8th August 2013. So May to May, then June, July.
Complaint initiated on?
Milord, this complaint was given, Milord, on 8th August 2013. 8th August 2013. And Milord, the hearing, purported hearing, Milord, that they are relying as Exhibit 1, that was held on 18th August 2014. In between, Milord, this 8th August 2013, Milord, the complaint, hearing took place, Milord, 18th August 2014. Milord, there was a show cause on 13th September 2013. These will be the relevant. So, Milord, what I intend to say, Milord, that the disciplinary authority from the very beginning was predetermined. Milord, they proceeded on the basis of, Milord, a purported complaint, Milord, which, Milord, the persons who made the complaint, Milord, they could not come forward, Milord, for the purpose of substantiation. Even, Milord, some outsiders were involved. Now, Milord, apart from that, Milord, it is the finding of the disciplinary authority itself, Milord, that Milord, appellate committee itself, that, Milord, the finding of the disciplinary committee, the inquiry authority was, Milord, without any basis. Milord, these 6 charges, Milord, I am really interested, that's why I have placed. my lord, the other charges are equally, my lord, those have been found to be, my lord, utterly without any evidence and absolutely misconceived. Now, my lord, why I said, my lord, I am keeping this short, not in details, my lord, only to the extent that is for the purpose of addressing the point of maintainability. Now, my lord, if your lordship kindly looks into, my lord, their writ petition, the grounds only. You know what? I'll be referring to the judgment of 2023 Gunasekharan's judgment. Yes. Lord, I will be relying on, Lord, why I am drawing your lordship's attention, Lord, to the ground. Lord, lordship kindly look at, Lord, page 35 onwards. I am not placing in details. My lord, kindly consider, my lord, this judgment. My lord, this is 2015 volume 2 Supreme Court cases, page 610. Relevant paragraphs will be, my lord, 2 to 16.
2 to 16. Or
Paragraph
2.
2, then, my lord, 14, 15, and 16. You have to kindly allow me a minute. No, my lord, not 2. My lord, my writing is para 12 to 14, 15, para 12 to 16. Para 12 to 16.
12 to
16. Now, this is very oft-quoted judgment. Lordship knows, my lord. Whether, my lord, the criteria and parameters laid down in paragraph 12 to 16 and, my lord, the grounds those have been framed. But these are beyond the scope of that. Paragraph 12, my lord, very precise.
Yes.
Despite the well-settled position, it is painfully disturbing to note that the High Court has acted as an appellate authority in the disciplinary proceedings, reappreciating even the evidence before the inquiry officer. In a way. Reappreciating evidence even before the inquiry officer. The finding on charge 1 was accepted by the disciplinary authority and was also endorsed by the Central Administrative Tribunal. In disciplinary proceeding, the High Court is not and cannot act as a second court of the first appeal. The High Court, in exercise of its power under Article 226 to 227 of the Constitution of India, shall not venture into reappreciation of the evidence. The High Court can only see whether the inquiry is held by a competent authority. That's not their ground. They have never challenged the authority. They participate. And they cannot rather, because being a state instrumentality. Then, the inquiry is held according to the procedure prescribed in that via, not the ground. There is violation of principle of natural justice in conducting the proceeding, not. The authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and merits of the case, not. The authorities have allowed themselves to be influenced by irrelevant extraneous consideration. This is also not. The conclusion on the very face of it, so wholly arbitrary and capricious that no reasonable person could ever have arrived at such conclusion. This probably only they can, but my lord, what they have done, my lord, why I have drawn your lordship's, my lord, the ground, if your lordship look into, my lord, only on, my lord, reappreciation of evidence. Without reappreciation of evidence, none of the grounds would be sustained. Then, the disciplinary authority has erroneously failed to admit the admissible material evidence. This is not their ground. The disciplinary erroneously admitted inadmissible evidence. This is also not their ground. My lord, it continued like that. My lord, I mean to say, the writ petition is beyond the scope of judicial review. the ground on which, my lord, they are trying to challenge is beyond the scope of the judicial review laid down by the Honorable Supreme Court. This is one judgment, my lord, paragraph 12 to 16. My lord, the other judgment is of recent one. My lord, kindly allow me to use, my lord, a live law citation. My lord, this is something that you can. (2023) Live Law Supreme Court 478. Indian Oil Corporation versus Ajit Kumar Singh. More or less the same. Paragraph 6 here. Ajit Kumar Singh. Supreme Court 478.
Yes.
7. Well, emphasizing the same principle. Well, I mean to say, if I like in my case, I have also challenged the same decision, involving the same set of evidence, the same parties. My approach before your lordship is twofold. I am not asking your lordship for appreciation of evidence. I thought of addressing your lordship on threefold. One is, there is no power of remand. As your lordship has formulated on the day your lordship rejected my prayer for interim relief. There is no power of remand. Authority is to act within the framework of law as it has been directed. It cannot be without the direction that has been given without that. It has to be followed like that. So power of remand is not there. Number one. Number two, I intended to argue before your lordship, that the finding and the punishment is tried to be imposed upon me was disproportionate by the disciplinary authority. Because the appellate authority was supposed to take that into consideration, reinstate me expressly. That finding of disproportionate assessment, disproportionate punishment in one of the judgment has also been deprecated by the Honorable Supreme Court. Here, we are very limited scope that I can argue before you. One, that's why, that they have in remanding, acted beyond jurisdiction, and the delay. My lord kindly sees. So, for point of judicial review, these two, Union of India and P. Gunasekaran.
As per the existing rule, whether the appeal committee can appreciate evidence?
Appeal committee can.
No.
Appeal committee can. Because appeal committee is the first appeal.
Yes.
Even according to these judgments also, the appeal committee can. Here in that case, the Central Administrative Tribunal, where for the first time they went before and there, the appreciation of evidence was well accepted. That part is there. The moment we come before your lordship, exercising jurisdiction under Article 226, the judicial review we are asking, here the scope is limited. But one matter I am arguing, but still, that is in the process of judgment. Here, there in that case, the labor court passed an award. Now, labor court passed an award, writ petition was filed. Writ petition went against me. Labor court award was in my favor. My contention is, the moment in the labor court, the appreciation of evidence, if that is to be challenged, then that acts as a civil court. That is to be challenged under 227. Supervisory. 226, that the moment we come, it has to be concerned with question of law and limited to the extent of limited extent. And it cannot be beyond that.
No.
Now, like this. Now, these two delay, I am really, because two dates, if your lordship kindly takes this into consideration, since when I have been suspended. Suspend করলো কবে? কবে সাসপেন্ড করলো? My lord, I was suspended in 9th December 2014. My lord, kindly takes note of this. 9th December 2014. Since then, my lord, I am embroiled in litigation. My lord, the decision of the appeal committee is 2019. The first lordship kindly take note of, below the disciplinary authority is 12th April 2018. Disciplinary authority, 12th April 2018. Then, my lord, 11th January 2019 is the finding of the appeal committee.
Discipline is 2018.
18. 12th April 2018.
Appeal committee?
Appeal committee is 11th January 2019. Now, appeal committee in 2019 said that so far the other 6 set aside, was nothing. There is no provision of appeal from that by the authorities. So far the other 6 remanded. Now, I had to prefer another appeal for the purpose of, so far these remanded 6 head of charges are concerned, but there was a direction for completion of the further disciplinary proceeding within 3 months from there. And in the interregnum, my lord, I was supposed to be under suspension for those 3 months. My lord, I will be placing that portion for those 3 months. Now, my lord, beyond that, what? If you have not completed that within that 3 months, and you continued just by filing, my lord, this writ petition, you continued to be, my lord, holding up, my lord, my joining the post, then what is the fate? What am I supposed to suffer? I cannot. Now, my lord, for that, my lord, this judgment. My lord, this is 2005, volume 6 Supreme Court cases, 636. এটা একটু জজকে দিই। এটা কপি নেই। Milord, this is, milord, paragraph 11 and 12.
এটা ওনাকে দিয়ে দিন। 11 and 12.
Yes, yes. Thank you.
11 and 12.
11 and 12.
Yes.
Milord, the head note itself says delay in initiation. Milord, there, milord, initiation itself was the point. Milord, I am 11 and 12 direct. Not under the circumstances, we are of the opinion that allowing the respondent to proceed further with the departmental proceeding at this distance of time will be very prejudicial to the appellant. Keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against a government employee should therefore be avoided, not only in the interest of the government employee, but in the public interest, and also in the interest of inspiring confidence in the minds of the government employee. At this stage, it is necessary to draw the curtain and to put an end to the inquiry. The appellant had already suffered enough and more on the account of the disciplinary proceedings. As a matter of fact, the mental agony and suffering of the appellant due to protracted disciplinary proceeding would be much more than the punishment. For the mistakes committed by the department in procedure of initiating disciplinary proceedings, the appellant should not be made to suffer. We therefore have no hesitation to quash the charge memo issued against the appellant. The appeal is allowed, the appellant be entitled to the retrial benefits in accordance with the law. Because in that case, the disciplinary proceeding was not initiated because of, milord, the dilly-dallying by the authority themselves. Milord, in my case, milord, even for argument's sake, today your lordship find that, milord, my challenge to, milord, those 6 charges, milord, the finding of the appellate committee was all right. Their writ petition doesn't vary. My writ petition also is not meritorious because those 6 charges remanded to be taken into consideration. My lord, kindly consider my claim. It was supposed to be done within 3 months, milord, since 2014. My lord, I was initially without subsistence allowance. My lord, 2014, my lord, I was under suspension. My lord, my subsistence allowance was not given. I had to come before this honorable court, file a writ petition, direction was passed, not given, contempt application had to be moved, then my lord, partially given, appeal preferred, appeal was not pressed. My lord, since thereafter, my lord, the completion of this disciplinary proceeding, and my lord, since then not a single verdict. My lord, now getting back to finding of the appellate committee itself again, my lord, page 158. This last portion, my lord, I will be placing before your lordship. 158. My opposition.
Yes.
Paragraph 21 onwards. For the reasons mentioned in the foregoing paragraphs, the report of the inquiring authority being vague, well, the entire report, the appellate committee's finding vague and not based on any reasons. The action taken by the disciplinary authority on the basis of such report, dismissing the delinquent from the service with the order dated 12 April 2018 is bad in law. Now, this paragraph says that, my lord, the report of the inquiry authority is vague in its entirety, lock, stock, barrel, not based on any reason. The action taken by the disciplinary authority on the basis of such report dismissing me, the delinquent, from the service with the order dated is bad in law. That order of dismissal is bad in law. Then what the appellate committee is doing after observing this? Therefore, considering the facts and circumstances of this case on the basis of the materials placed before us, we are of the opinion that order of dismissal passed by chairman of the respondent council against appellant dated 12th April 2018 is liable to be set aside. So my dismissal order was set aside. In the light of the observations made in the preceding paragraph, and it would be appropriate for issuing direction. My lord, this is where I am agreeing. I am saying that you are satisfied that the entire thing was vague. It was without any reason. You have observed that, my lord, they have proceeded without any material evidence prejudicial to me, preconceived on the basis of assumption. My lord, I placed before your lordship.
Yes, yes.
Now, my lord, even then, my lord, the appeal committee, after observing this, has chose to remand me before the same authority, before the same tiger to be usurped. My lord, it says that the liable in the light of the observations made in the preceding paragraph, and it would be appropriate for issuing directions to conduct fresh inquiry on charge being number 1, 2, 4, 7, 10, and 11 strictly in the light of observations made in subparagraph 1, 2, 4, and 7 of paragraph 11 under the heading decision with reasons. That's why, my lord, only those portions I have placed before your lordship. So appeal committee found it to be vague, unreasonable. My lord, that order was set aside. But the moment that order of dismissal is set aside, it is imperative, my lord, that, my lord, I am in service. Because my order of dismissal is no more there. My lord, that has been explained in the next paragraph. I will not argue that. The instant appeal being, my lord, 13/2018 is allowed on contest, and the order of dismissal of the appellant from service with a clause of disqualification for future employment as a teacher dated 12th April 2018 passed by the chairman DPSC Howrah stands set aside with a direction to cause of fresh departmental inquiry with respect to charge number 1, 2, 4, 7, 10, and 11 of the charge sheet dated 9 December 2014 in the light of the above observations against the appellant after giving her sufficient and reasonable opportunity of being heard, and to conclude such inquiry within 3 months from the date of communication of this judgment and order treating judgment and order treating the appellant as if she is under suspension for an uninterrupted period since the order of suspension. So, my lord, my order of dismissal was not there. I have been treated to be under suspension. I have been treated to be under suspension. My lord, worst possible case. My lord, I am entitled to get suspension allowance continuously since the date of my suspension. Since 2018, it has been stopped. Now, see, under suspension for an uninterrupted period since the date of order of suspension. The chairman, DPSC Howrah, shall be at liberty to appoint fresh inquiry officer, and the earlier inquiring authority is not available at his disposal. The rest charge be treated as dropped. Rest of the charge be treated as dropped. However, the chairman, DPSC Howrah, is at liberty to consider any application of the applicant in accordance with the rules, if made, for withdrawal of her suspension during the pendency of the authority. You know, this part, I again moved before the appeal committee because they are not doing anything. Milord, appeal committee, Milord, was not functioning in the meantime. I moved in the year 2019 itself. But I have, in my petition, I have stated so. The other petition, Milord. Now, the appeal committee started functioning again in the year 2024 on. In the meantime, Milord, because of COVID and other things, it was not working. Now, Milord, the appeal committee second time observed that because of pendency of this writ petition, they can't do anything. And that appeal was disposed of. So this, Milord, to apply again, because authority was not listening to me, I choose to again apply before the appeal committee for praying for that. Let us, even for worst case scenario, implement your order itself. That was also undone. Milord, this is the scenario. So, Milord, my twofold, Milord, so for the maintainability, I have said, it has to be judicial review, Milord, within the parameter as laid down by the Honorable Supreme Court. Writ petition is beyond that. Milord, the District Primary School Council today cannot come before your Lordship. I cannot come before your Lordship seeking, Milord, reappreciation of evidence that, Milord, appeal committee has faltered here. That is what. Now, so far, Milord, my entitlement is concerned, Milord, that is within the rules, Milord, I have to argue. Milord, should I argue this today itself, or, Milord, after they satisfy your Lordship on the point of maintainability?
No, you complete.
Wait a minute.
3টের সময় যেটা ফিক্সড আছে ওটা কি আছে দেবনাথ বাবু? 3টের সময় যেটা ফিক্সড আছে টাইম দেওয়া ছিল না? না, যেটা অ্যাসাইন্ড 3টের সময় এটা বললেন না?
লাইব্রেরি ওটা দেখে একটু অ্যাকসেন্ট দিবি, লাইব্রেরি এটা একটা লিখে রাখো, এটা লিখে লেখা নেই।
কত কালকে মেনশন করবে? অ্যাসাইনমেন্টের টাইম ছিল না। আর এটা টাইম কোনোটা দেওয়া নেই, এগুলোতে টাইম দেওয়া আছে না? 2:59 টাইম দেওয়া আছে না? ঠিক আছে, হিয়ারিং এর পরে একটা লিস্ট এটা দেখি কি কন্টিনিউ করে যাক।
Lordship kindly takes the West Bengal education.
Let me try to understand one thing, clarify that situation, that para 21 says that the report of the inquiry authority, is it mentioning exhibit 1?
Paragraph 21 of
page 158 of your opposition.
158.
Yes. This inquiry authority
for the reasons mentioned 21.
Yes.
For the reasons
being vague
in the foregoing paragraph.
Is it after issuance of so cause and prior to initiation of the disciplinary proceedings, the inquiry held by the authority, or the inquiry officer passing an order upon completion of the disciplinary proceedings? Which report it is stating as vague?
Inquiry officer, after completion of the inquiry proceeding, passed his order. That inquiry.
The final order after disciplinary proceedings.
Final order after disciplinary proceedings.
Okay.
So it says that inquiring authority being vague, not based on reasons, the action taken by the disciplinary authority on the basis of such report. So inquiry
Why I am
report,
asking so, why I'm clarifying it, because if it is remanded, then a window is open for collecting a fresh evidence. So far as this order import is concerned, if it is after the disciplinary authority, sending it for remand without collection of fresh evidence will be a futile exercise.
Fine. I'm grateful, Miller.
That's why my inquiring authority means after the disciplinary.
After the disciplinary inquiry report, after inquiry report, the disciplinary authority affirming the report. That's why disciplinary authority they are saying.
So there is no additional evidence as such to be collected on remand.
But Milord, that's what the so far Milord this remand is concerned. Milord, the observation of the appellate authority imposing so.
In which line?
Milord, this Milord heading Milord 7 Milord I was reading. Milord, this para Milord, as it has been mentioned in para 11. Milord, at page 152. Ground 7. Page 152, ground 7. In the order also mentioned. Ground 7. Then Milord 153, just before ground 8. Just before ground 8.
Yes.
May I read it?
Yes.
In the instant case, Milord, just after middle portion, in the instant case, the inquiring authority neither inquire into the fact that who has entrusted the fund with the delinquent and how it was to be managed and who were responsible for keeping the accounts of the fund, and therefore the inquiry on this issue remains incomplete, and no inference can be drawn on the basis of such incomplete inquiry based on incorrect evidence, and therefore we are of the view the inquiry authority came to a misconceived finding, ignoring the rule of best evidence and the other relevant facets associated with the imputation, and the same is perverse and bad in law. There is a finding, it is perverse and bad in law. Milord, on the charges of 7, 10, and 11, perverse and bad in law. Still, Milord, it has been remanded. Milord, as it has fallen from your lordship that if at this stage it is remanded, it leads to Milord, either two things: fishing out of evidence or manufacturing evidence. Fishing out of evidence, because so far, Milord, the evidence available on record, this is the specific finding of the appeal committee that it was incomplete. It
would have been a case that the evidence is on record, but there is no appreciation.
I'm grateful.
Appreciation of that evidence, then you can remand it. You appreciate such evidence in the light of such and such observation.
I am grateful.
But it goes with the similar set of evidence before the authority which has passed the order.
Well, had it been a scenario involved like Milord Order 41, Rule 27, not. Well, as it has fallen from your lordship, I also really didn't think of that. I was thinking of that this remand itself is bad because it is beyond the scope of law. I was keeping myself within the scope of law, but it's a fact, Milord, that will lead to Milord manufacturing of evidence or fishing out of evidence.
Yes.
Any other query, Milord?
No.
Now, Milord, first volume of Milord Education to Jachakuddin Rata. দিলাম না দিলাম My lord has been pleased to get that. My lord,
Which page number?
Yes, I am giving it to you, Lordship. My lord, they have initiated the inquiry on the basis of the conduct rules they have followed. So I have nothing much to say. That was within the para. My lord, appeal committee regulation. It is, my lord, in your lordship's book, my lord, it should start from page 179. And at the bottom of the page, my lord, the page numbers are given. Page 179. Is it telling? West Bengal Primary Education Appeal Committee Regulation 2012.
Yeah, yes.
Now, Lordship kindly straightway comes to, my lord, Regulation 9 at page 182.
Yes.
Appeal Committee Regulation 2012. Now, my lord, Regulation 9, my lord, subsection 1 clause B. A is not applicable to me. B. In an appeal against an order of discharge or dismissal. This is applicable to me because I was dismissed. Allow the appeal. What can the appeal committee do after? Here. Allow the appeal and make an order directing reinstatement of the appellant with or without such relief as may be found consequential to such reinstatement. This is one. If it is of the opinion that such reinstatement is appropriate and proper. So if it is from the order of dismissal, one course, the moment appeal committee find that the order of dismissal was wrong, finding of the inquiry authority was wrong, and disciplinary authorities affirming the inquiry officer's the finding was wrong, vague. It was set aside. Order of dismissal was set aside. The alternative that was there, that is B subclause 1. Clause B subclause 1. Allow appeal, that has been done. The appeal has been allowed. Make an order directing reinstatement. This has not been done. Here I am aggrieved. Reinstatement of the appellant with or without such relief, whatever the relief the appeal committee may have thought of, as may be found consequential to such reinstatement, if it is of the opinion that such reinstatement is appropriate and proper. Then the other alternative,
Yes.
Then below 2 is also relevant, subclause 2. But that scenario, in my respectful submission, subject to appreciation by LHC, has not arisen as yet. What is it dealing with? Allow the appeal and make an order directing payment of gratuity to the appellant calculated at the rate of 1 month's salary for each completed year of service, subject to a maximum of 12 months salary. If it is of the opinion that such payment of gratuity would be appropriate relief to the appellant instead of making an order of reinstatement. So the other alternative. If the order of reinstatement is not there, then the other alternative, if the appeal is allowed. In my case, the order of dismissal is set aside. I have been put under suspension under the appeal committee's order itself. I have been deemed to be continuing under suspension. That means I am in service. Impliedly, I am in service. So, my lord, clause 1 applies. Clause 2, my lord, to my reading, suppose today, my lord, continuation of this litigation, my superannuation happens. If my superannuation happens, my lord, there won't be any possibility of clause 1. Reinstatement won't be possible. But in that case, the only possibility will be below 2 within the regulation. Or 3, dismiss the appeal, below 3 doesn't apply to my case because my appeal has been upheld. So if the appeal is allowed, the only 2 alternative, my lord, is remaining with, my lord, the appeal committee. No question of remand. The appeal committee has to act within this.
Okay.
Because, my lord, they are creature of statute, bind by the statute. Now, my lord, getting back to the conduct rule ones. That this is, I have placed before your Lordship, my Lord, West Bengal Primary Education Appeal Committee Regulation 2012. My Lord, Regulation 9, Sub-Regulation 1, Clause B, Sub-Clause I. This is to be precise my case. The remand is not permitted under this point. Now, my Lord, yes, finding that the appeal is allowed and, my Lord, the order of dismissal is set aside. There was a direction, worst case scenario, to argue against myself. That, my Lord, the authority, what should have been the course that is available to the authority to complete it within 3 months, as was directed. I say that was bad, but still, now, my Lord, Lordship kindly comes to once, my Lord, West Bengal Primary Education Conduct of Service of Teachers Rules 2001, my Lord, page 122 probably of that book, page 122, earlier than that regulation. It starts from earlier. I am on, my Lord, rule 11.
Yes.
122. Page 122, Rule 11. A teacher may prefer an appeal against an order imposing penalties mentioned in Rule 8. The penalty was imposed under Rule 8 upon me to the appeal committee constituted under Section 91 of the Act. But I preferred that appeal under Rule 9 of this rule. Then the decision of the appeal committee shall be final. And my Lord, this is binding. Then Rule 12. Then Rule 12 of this rule. The authority which passed the order appeal against. That means, my Lord, the District Primary School Council, the disciplinary authority. The authority which passed the order appealed against, I appealed against that order, shall give effect, mandatory, to the orders passed by the appeal committee.
Yes.
And in doing so, it shall furnish to the teacher concerned copy of an order passed by the appeal committee. My Lord, here in this case, my Lord, the authority, instead of acting in terms of Rule 12, has chosen to prefer a, my Lord, judicial review for the purpose of judicial review before your Lordship. To which I argue that the grounds, my Lord, those have been espoused or intending to be espoused are not to be gone into, are not permissible under the law, not permissible under the parameters laid down by the Honorable Supreme Court. So,
yes.
So, my Lord, to concise, my Lord, my initial argument, my Lord, so far, my Lord, their writ petition is concerned. On the basis of those two Honorable Supreme, there are other judgments also. Instead of, my Lord, multiplying the very crux of, my Lord, the principles, my Lord, that I have placed before your Lordship, my Lord, all the grounds are inviting your Lordship to reappreciate evidence as a second appeal court, which it cannot. Now, my Lord, there is finding of the appeal committee which says that the inquiry authority and the disciplinary authority affirming the finding of the inquiry authority was entirely vague. It was on conjecture and surmise. In the body, my Lord, those have been written. Now, my Lord, still, my Lord, the law says that if the appeal is allowed and the order of dismissal is set aside, the only alternative is to be reinstated. Language of the order says so, because I have been put under suspension with a time limit. Yes. And, my Lord, there cannot be, my Lord, any remand. In this situation, my Lord, this petition, my Lord, that has been preferred by the District Primary School Council is not to be entered. And, my Lord, so from my petition is concerned, on that point of law, my Lord, I will be relying on, particularly, my Lord, Regulation 9, Sub-Regulation 1, Clause B, Italics 1.
That is all.
My Lord, one judgment, my Lord, this is on primary school of our state itself. My Lord, this may also be very off-quoted because it's a old one. 2014, Volume 2, Calcutta Law Times, 439.
Volume?
Volume 2, Calcutta Law Times, 413. Lord, there in that case, Lord, I'll hand over the book. Lord, here, Lord, I only have the book.
Okay.
Lord, there in that case, Lord, here I am not, Lord, segregating to paragraph. But here the fact was, Lord, there was an allegation of misappropriation, defalcation, misconduct, everything. And in that case, it was more severe. Lord, there was a criminal case also initiated. Lord, the law says, Lord, the regulation 8 of the conduct rule says, if I am more than 48 hours, Lord, in custody, then mandatorily I have to be put under suspension. And that suspension will continue. I'm sorry, Lord, that is section 7. 7, Lord, under which, Lord, I have to put under suspension, under the act. Now, Lord, he was put under suspension. Lord, that, Lord, this criminal proceeding ultimately was quashed, could not be substantiated. And then, Lord, the disciplinary proceeding continued. On that premise, the case was taken up, and Lord, the appeal committee's finding was there. Here, the Honorable Court was pleased to observe that the incumbent should have been reinstated because it is to be deemed that he was honorably acquitted. The point of argument there, here it is not directly applicable because in this case, Lord, why I am relying on this, Lord, to point out that if so much of allegation of misappropriation of fund, defalcation of fund, for argument's sake, Lord, is there a single complaint to the Lord, implementation authority? Any complaint to the police? Because this should have been the first thing that should have been done.
Yes.
Today, it does not lie in the mouth, Lord, to come and say that misappropriated. There are procedures prescribed under the law. That was not invoked. I say it was only for the purpose of victimization because I intended to stand in the way of mismanagement in the school itself. And within 1 year, Lord, Lord, their grudge, Lord, fallen upon me.
Yes.
Lord, this honorably acquitted point, though not applicable, but it seems, Lord, it's relevant to the context of the case. That's why, Lord, I am relying on this. This.
Take it up any day, my lord, will reply to my lord. First maintainability point, then my lord. If we succeed, my lord, then.
Maintainability will ultimately lead to the merit of the case because their merit is involved with the maintainability that you cannot go into the Lord.
Appreciation of evidence.
I'm ready.
Ashun. Mr. Sudeep Ghosh, learned advocate for the writ petitioner in WPA 5761 of 2025 and respondent number 6.
In their writ petition, respondent number 1.
Respondent number 1 in WPA 9587 of 2019, who concludes his argument. Mr. Ratul Viswas, learned advocate for the board, seeks accommodation on the ground of Mr. Tuvir Sannal, learned senior advocate.
For the council.
For the council, no. Mr. Sannal will argue on behalf of the council.
Council. My lord, board is not a relevant party.
Council. Board not a councillor. কবে দেব হিয়ারিং? মার্চ মাসই দিও।
One interruption, Lord, if Mr. Bari is there on Lord online.
দেখুন তো মিস্টার বাড়ি আছেন অনলাইন।
Because he is supposed to lead me, but
বাড়িটা বড় বাড়ি।
একরামুল বাড়ি।
ভাইয়া ভোট এখন।
সেটাই সেই জন্যই
আছে।
Probably, my lord, he should have been now. I told him to be, because my lord, he has participated in this bar council election and other.
Oh,
He is now moving.
no, he is not here.
But one thing, your lordship, my lord, in the course of, in the list also, my lord, it is written that in person. My lord, the writ petition was filed initially by the, my lord, the chairman of the council. Because, my lord, at that point of time, there was a, my lord, strike
opposition
of the by the bar. So, my lord, the chairman himself, my lord, filed the writ petition. And, my lord, thereafter, my lord, he has given a no objection and, my lord, given us a power. We have filed the Okaladnama on, my lord, 11th June 2019 and the A9538. Now, I am the advocate on record. I was advocate on record and I am the advocate.
Okay. So shall I record this in the order?
Yes, your lordship may record it because otherwise, my lord.
Okay. একটা note করুন যে it is indicated by Mr. Ratul Biswas, learned advocate representing the council, that at the first instance, the writ petition being WPA 9587 of 2019 was filed by the chairman in person, within bracket in person. However, subsequently, he has filed Vokalatnama on behalf of the chairman on
My lord, I have filed it on 11th June 2019.
11 June 2019.
By number, my lord, capital A 9538.
Capital A 9538, filing number. VD filing number, capital A 9538. এটাকে ইন পার্সন করবেন না, ঠিক আছে? আজকে দেখুন এটা শান্তনু সিনহা ইন পার্সন আছে না, এই ইন পার্সন কথাটা থাকবে না, ও ভোকালতনামা ফাইল করেছে। বলো ডেট বলো।
রাতুল বিশ্বাস হয়ে যাবে।
এই দেবনাথ বাবু ডেট বলুন কবে দেবো, যেদিন হয়ে যাবে। হ্যাঁ ঠিক আছে 2 PM ওখানে কিছু 26 মার্চ।
এইটা বলা দরকার আছে
মিস্টার ঘোষ
আম সরকারের না
দিনই বার করেছে। আচ্ছা আর এটা হচ্ছে অ্যাফিডেভিট ইন অপোজিশন ফাইলড ইন WPA number 9587 of 2019 is taken on record. Copy sir. কবে হচ্ছে?
আমাদের বারাসিয়ান ক্যালেন্ডার শো করছে না।
মার্চে কি আছে কিছু নেই,
বুধবার
27th মার্চ একটা ছুটি আছে, 27th মার্চ একটা ছুটি আছে, ফতেহার দোহাম বাইরাম কিছু একটা কি আছে।
23 তারিখ দেখো পেনশন।
Ramnavami is 27th March. 26th is not holiday.
7th March is holiday, my lord. 26th is not.
But it's showing 26 in the high.
Our calendar is showing, my lord, Bharatian calendar 27th is holiday. কিন্তু আবার Bharatian calendar তো
ওইটা দেখান না, ওই যে ক্যালেন্ডারটা আছে।
হ্যাঁ my lord, I've seen my lord, I've seen just now my lord, I've seen.
Oh.
So one day we will come, you will not come. The other day we will come. তাহলে 30th সেফলি 30th করে দাও মিস্টার ঘোষ on 30th March. ফাইন্ডিং ডেট এর আগে আছে 23 তারিখে দেওয়া যাবে, দেখো তো 23rd ফাইন্ডিং আউট
ফার্স্ট হাফ অফ মার্চ, otherwise it will go out of
মানডে
our
টিউসডে
mind.
দেখো, মানডে টিউসডে তে দেখো 23rd দিন
23rd
March.
One humble prayer may I make. My lord has
I have to
studied it
understand.
in detail. Lord Hardin part, my lord, in that case.
Yeah, I have no objection, your lordship can do it.
Hardin part.
নাহলে আবার চেঞ্জ হবে, আবার তোমার
এরকম বহু মামলাতে এরকম
না না না, আমাদের কোনো অসুবিধা নেই। 23rd March, দেখো 23 তারিখ হবে
না না 2 PM করো,
2 PM
2 PM
23rd. Correct.
My lord, this matter was fixed on today at 3 PM.
Which matter, sir?
This is the last order, my lord.
What Krishna Klikanis?
কিসের এটা?
Medical student.
অ্যাসাইনটা কেন টাইম দাওনি কেন? You are for the?
I am for the respondent, my lord.
Where is Mr. Datta?
He is here.
And the other side, petitioner? You are for respondent?
Yes, yes.
Respondent?
In can
The applicant?
can application.
You are the petitioner in the writ petition?
Yes.
দেখো both sides আছে কিনা তাহলে হবে। Where Mr. Srijit Chakraborty is there for the applicant?
Both side petitioner তো নেই, মানে applicant নেই।
Better fix another date then.
Next বৃহস্পতিবার।
না ওভারল্যাপ করাবে না নিতে পারবো একটা ধরলে ও ওয়েট করে হবে না
এই দেখ এইরকম ভাবে লিস্ট অফ ডেটস কি সুন্দর করে করতে পারে। এতটা লেখাটাও ভুল করেছে, তাহলে সেটা বলে দেবো, কিন্তু খুব সুন্দর ভাবে করেছে এবং লেখাটা বাজেভাবে দেখতে ভালো লাগবে, সুন্দর করে করতে হবে, এরকম ভাবে করতে হবে।
ওকে আপনি 30 তারিখে দিন না কত কত আসছে দেখো আমি যেখানটা অ্যাসাইন দেবো 23 তারিখে দেবো এটা এখানে কখন দিলাম 30th 23rd 25th কি আছে ওয়েডনেসডে তে মাদ্রাসা থাকে না 25th আছে না তার
কি বার হচ্ছে
আছে
23rd?
হ্যাঁ মার্চে
বলে দিচ্ছি জজ সাহেব,
না তাহলে
একটা
দেবেন
মামলা
26
রিভিশন করেছি, জজ সাহেব
30 তারিখে অ্যাসাইন ডেট
কালকে ফিক্স করেছি, তো কালকে তুমি তো থাকবে না বলে দিস।
investigation has been concluded
Investigation, state will inform, my lord. I don't know.
you're an accused no
No, no.
investigation is going on
Yes.
it has been concluded do you have any information whether investigation concluded
No, I have no information.
30th on 30th March find out
30th March.
yes
But one matter, your lordship, my lord, upon mentioning by the petitioner, my lord, notice to my client, my lord, mention the matter before your lordship on the basis of the mentioning, your lordship has fixed it, my lord, tomorrow, my lord, immediately, my lord, when they intimated it also to my client directly, the board, my lord, as soon as I get the information from the board, I write to the, my lord, I wrote to the, my lord, the advocate on record of the petitioner, therefore, after you, please communicate us directly. And my lord, your lordship has fixed it on 20th tomorrow. My lord, we have said, my lord, that Mr. My lord, we have some difficulty on 20th. Please act accordingly. My lord,
who is the learned advocate
my lord, Mr. Mohana Bandyopadhyay, I do not know, my lord.
অনেক দেরি হয়ে যাচ্ছে।
I've intimated the advocate on record also. My lord, the predicament is Mr. Sandal is, my lord, leaving today. My lord, outside the, my lord,
when he is coming back
my lord, he's coming back on Monday. The Tuesday, he's, my lord. It is not that immediately, my lord, that 22nd is that examination, or, my lord, 23rd it has to be, but there is an urgency, my lord. It may be, my lord, any subsequent, my lord, for your lordship's convenience.
is it relating to any matter of 18 months and 2 years
Yes,
validity?
yes. NIOS matter. Absolutely right. Any day, your lordship, my lord.
Tomorrow we'll see let them move let it come up in the list you will be there
I will be there.
yes
I will be there, my lord.
let the petitioner
I will reply, my lord, your lordship. Kindly, my lord, accommodate.
let the petitioner first move the application let us see what is his prayer
My lord, great.
on 30th
My lord, instead of March, in this month, February, my lord.
I would have been very much pleased if you could have accommodated you in the month of February. If the persons are coming, listing 3 matters were there, 1 matter could be heard, 2 had to be adjourned. No time. Come on 30th. So in the meantime, the investigation will proceed. If they file the final report, then we can dispose of the CAN application altogether. Right? But give a notice to Mr. Srijit Chakraborty.
Yes.
Great.